conversation we're going to be having tonight with someone who is really trying to make change in the family court system. Go ahead and please like this page. If you like this live, just go ahead and like it, share it with your friends. We need to get as many people as we can to watch this live tonight. Inviting into the live Florida House Representative candidates for District 74. Chris Felder is going to be joining me.
I'm here.
Are you there? You are here. Chris, hang on.
Here.
Let me just go ahead. Let me try to see if I can get a better view here, because we got a little bit of let me change this layout so I can.
And I'll have my camera on in a moment.
All right. Well, that'll work. That'll work.
Yeah.
Well, hey, just go ahead and like and share this live. This is a very important live that a lot of people need to hear, because there are just so many people hurting through what I call a silent epidemic, and it's the family court system. And we got Chris Felder joining us tonight. A lot of people from Sarasota, if you know them, go ahead and hashtag this, share that with them using the hashtag Sarasota. He is running for the Florida House Representative, District 74. And we got legislation coming up in 6 months away?
Yeah, the session will start in January. Committees will start before then.
Yeah, so we got about 6 months to push. When is the election for the House Representatives?
My general election will come up November 3rd of 2026.
Okay. All right. So we got a little bit of a year and a half from that, but we need to start fighting for these bills to be pushed before then.
Yeah. With any luck, we'll get some of these matters resolved in the upcoming session, so they'll become law before my election even comes up.
Go ahead and if you're just joining in, go ahead and like this live, share it with your friends, tap that screen so it can hit the algorithm. Talking to Chris Felder, and we got some important things that we need to talk about, because one thing about the current family law that is written is, well, it's outdated for one, and for two, it just doesn't protect everybody. And I've got a nasty fly that just won't leave me alone. I got someone join. Someone doesn't want me to do this live tonight. All right, so we're gonna get started here. We're gonna have a Q&A session tonight. So if you know anybody that has been a victim of family court, maybe they're surviving family court, or they are a survivor, or they're still battling through this, and they might have any questions, want to know really and understand what some of the case laws are, the statutes. We can't help everybody within every state, but in the state of Florida, the laws are, I think, would pretty close to some of the other states. They might be off a little bit. There might be some deviation, but really understanding what you're battling against is going to empower you to win to fight and to win your cases the best that we can. This is not legal advice. We're not here to give you any legal advice. We're just here to provide you with some information on how you can help us change the laws that are currently written, and to help you know and understand a little bit better about what you're facing when you walk into the family court.
Well said. And I'd love people to understand better some of the laws, or some of the principles in law, so that people are not so inclined to feel that they're victims when really they're more victims of circumstance, right? They're victims of their own ignorance. They don't understand how some of this stuff works, and it doesn't satisfy their instincts. So therefore, they're quick to say things like the system is corrupt, as opposed to in some of these instances, the system is working exactly how it was intended to, and you just have to learn the game. You have to understand the rules in order to win at the game.
Chris, did you shave?
No, my
I'm just
face
asking.
looks just like yours.
I was wondering. Alicia was like, "Are you going to shave for the live?" And we don't see your face tonight, so
I'm driving, but I'm gonna be stopped shortly, and then I'll turn my camera on. No,
that's great.
I did put on a collared shirt though, so I'm trying to. This is Sarasota styling here.
Well,
we're not known for dressing up here.
Let's also want to make something clear too, because there's, this is a very sensitive subject, and everyone is hurt by it in one way or the other. And when it's something that's separating you from your children, I mean, that's got to be the biggest heartache and the biggest hurt that anyone could feel. And some people aren't just mature enough adults to handle that situation to be good co-parents. And unfortunately, I know that this to be true and to be a fact that some people have paid the consequences, and they're the ones that saying the big C word about family court. And it's just, to me, in my eyes, it's just justice being served. And that really makes us walk a really line when you're trying to help somebody out, because you really want to know exactly what their backstory is, where they've come from, and how they got to the situation that they're in. My experience, I want to claim that family court is wronged me. I don't think that it's intentional. I don't think that the family court is like the judge is sitting up there that has a vendetta against me and wants me to suffer and hurt, because they don't know me personally. I don't think they're getting paid money. I don't think someone's putting money in their pockets. Now, I'm not saying that to be true for all systems, all counties, but in my experience, I just feel like the family court system is so outdated and it's so overrun that it needs support, and it needs to have a better written language, so that way it can run more efficiently instead of like it did back in 1983.
Agreed. Agreed. Strong agreement.
So there are a lot of people, and I get it. We want to say it's a family court. And in some cases, there are systems that are wronging people, people with money and people with power who are fighting their ex, might be able to sway some decisions every once in a while when it comes to election. And that's just, there are, I would say, some bad actors. But I think the system as a whole isn't really a system that is out to design to hurt families. I think they're trying the best that they can. They're just too busy to really do anything. And the first thing that we got to do is rewrite those laws.
All right, I'm sitting still now.
All right. All right. So if you're there, you are. He's Chris is just now joining us, and well, he's been here, but you can see his face now. If you have some questions to connect with the person that we're talking to, we're going to be asking if you have any questions tonight. Chris is here to help you navigate those questions. I want to go over a little bit what your letter to the legislators that you sent out. Tell everybody, if Alicia's in the chat, I know she's in there. Chris is actively working on legislation to fix our vague subject laws. I'm going to go over some of those real quick, but how can somebody go find this letter? Do we need to send a link to them? Is there a page or somewhere, a website that we can go to so we can send this out, or they can see it for themselves?
I think, I hope somebody puts something in here. I think that's on our Linktree link.
Okay.
Yeah, Alicia, if you're out there, if you'd make a comment in there, I think it's in the Linktree link. And I'd be happy to address what it says in the letter. If I may, not to deviate, not to sidestep your question, but if I can answer a different issue first. You mentioned, and I don't mean to pick on your words, your choice of words. You said it was an epidemic. And I vividly remember a conversation I had with a legislator who asked me to come speak at the Florida House Subcommittee for Children and Families. She said, "We'd like you to come speak on the epidemic of fatherlessness." And
Mm-hmm.
very quick, I was to say, I don't believe that there is an epidemic. And this is right, kind of on the tail
Yeah.
of COVID.
What?
I was saying,
1 second. I don't mean to interrupt. I just want to say hey to
no, it's
Michaela.
fine.
We see you. Well, I see your question out there. Just give us 1 second, and we'll let him finish the statement. We'll bring you in if you don't mind. If you want to step into the live tonight, ask Chris a question. I see your comment. Just let me finish this, and we'll get right to you. Okay. All right. Go ahead.
I this one legislator said, "We'd like you to come address the fatherlessness epidemic," and I responded with, "I don't believe there is an epidemic. Epidemic, given that we just been through a pandemic, implies that we don't know how it started, we don't know why it's contagious, we don't know how to fix it, and that is a complete denial of government's active involvement in separating parents from their children, whether it's done with intention or not. You can't deny that government created the system, and government has exacerbated the system. So let's not deny that, is essentially what I was saying. So I wasn't meaning to, again, pick on your choice of words. I just thought it was a good opportunity to talk about that. And I'm happy to jump into the letter, but should we answer some questions first before getting to the letter?
Yeah. Yeah, Michaela Jade 89, thank you so much for your question. She just wants to stay in the comments, and you're more than welcome to do that. She says, how to deal with my exes who's hurting me through my kids. It's kind of
Oh
a
boy.
broad question.
Yeah. And as you know, I'm running for public office, right? I'm running to help write and amend laws. So I'm not sure I'm the appropriate person to answer the family dynamics or the psychology, but I would imagine coming from the perspective of the law, I would try to understand whether or not it's a violation of the law, understand whether or not it's a violation of your court order, and if so, attempt to enforce it through the family court, through law enforcement, through DCF. Um, without understanding more about your personal circumstances, I'm not sure I can give a more in-depth answer.
Yeah, I mean, we're all being hurt through. I mean, not all of us, but those who are experiencing the direct parent-to-parents parental alienation. It is very hurtful. And the only thing that I can say, because I've been there and I'm still fighting for that, but it's just to empower yourself, stay strong, don't react. Reaction is probably going to be your kryptonite. The way you react, the way you handle the situation is going to can impact on how the future is for you. So if you stay calm and stick to the facts and do your best to understand the case studies and that what we're going to explain tonight to you can help you manage through that. And it is hard. I know it. My kids have said some nasty things to me. They're young. It's not their voice. It's someone else's. You just have to understand that it's them, it's someone else's voice, not theirs. They're just being used. They're part of the weapon to hurt you, and it's not their fault.
If we were going to have an evening where we just talked about cluster B personality disorders, right? Two guys who aren't qualified to talk about it. Um, I think my best advice to somebody who's new to dealing with somebody with a cluster B personality disorder would be to not invite them into or not to allow them to bring you into their vortex of insanity. So
Mm-hmm.
hopefully you're communicating with this person through an app that time date stamps everything, and don't communicate with questions. Don't ask if things are okay. Hey, is it okay if I bring Junior at this time? Is it okay if I pick up Junior at this time? Don't ask questions. All you're doing is allowing them to invite you into their crazy, into their hurt. So I would communicate with kind of matter of fact sentences. I'll be there at 5 p.m. unless I hear differently from you.
Mm-hmm.
You just kind of have to change the way you communicate, which is obviously not the way you communicated when you were, you know, trusting this person.
Yeah, Michaela, thank you so much. You're very welcome for that. Also, we do have some other people who are in the fight in the crusade that might have some advice for you. You could take their advice as well. Thank you for the hearts. Thank you so much for that. We appreciate it. If you would please do us a favor, go ahead and share this, push this live out. We got some important things to get to tonight. If you have a question, we're going to give you a couple of minutes. You can pop into the live. You can ask the questions directly to Chris Felder. We're talking with him. He is for the Florida House District 74 candidates. His campaign kicks off next month, from what I understand, but we are just 6 months away from legislation in the state of Florida. And if we can push this bill through one state, maybe we can start pushing it through the next and through the next. And I know there's a lot of comprehensive bills out there that are being pushed out to the states, and there may be some, but when I'm looking at yours, Chris, what we have is a step by step. This is the problem, like the statute, and this is the problem with it, and this is the fix. It's like, here's the problem, here's how we fix it. Here's this problem, here's how we. It's pretty cut and dry. And the one thing that I like about it, it seems like it's a safe bill. Like, it protects people from false allegations, and it really puts more accountability to those who are doing harm to the other parents. Let's say if you have a question, let me just see here real quick before we get back into this, Chris. After Father's Fight, if you want to just jump into the light, go ahead and put a 1 in the comment. We'll invite you in and you can talk to Chris directly. Father's Fight. How do I get the judge to honor his ruling in orphans court on a due process violation that happened?
I think you're asking for legal advice that I wouldn't be qualified to give you.
Yeah.
Uh, I'm sorry.
Yeah, just keep in mind we can't give any legal advice here. Chris is running for. He's trying to change the laws and change the bills. If you have something that might be affecting you in family court, you want to know how to approach your judge or your attorney, or how to approach the issue that you're having. I mean, we got Ash Cash who wants to jump in on the live. Let me go ahead and get her in here, Chris, and she wants to ask a question. Let me see if I can invite her in real quick, and. All right, if you go ahead and share this live out and tap on that screen, hit it so it hits the For You page so we can get the algorithm out to push more people to get into this, because we got an important message that we want to talk about tonight. Ash, I guess, welcome into the live. Do you have a question for Chris?
I do have a question. So I have tried really hard to work with my son's father with some addiction issues and mental health issues. We've gone to court. I've supported him getting healthy and stuff, but he started dating this girl who is not particularly enjoying him being the healthy version of him, or us having a conversation or talking alone one-on-one about our child. We started working together, and then we went to our son's graduation together, took pictures, and then it all kind of fell apart. He started saying that she was uncomfortable, and then my son made some accusations. And when I brought it to him, he said I was being bitter. My son also told me that he told dad on this visit as well. Like, what do I do if, like, dad is letting the girlfriend trump what our son is telling him and telling me and pushing under the rug?
I don't know that you're going to like this answer, but unless there's abuse or harm,
Yes, there is
emotional
abuse and
injury
harm.
to the, well, I gather from your question that it's to you.
No, no, no.
Um,
It's to
but
the
if it's
child.
actually if the child is being emotionally injured, are you in Florida?
No, I'm in New York.
You're in New York. I'd have to review the statute. Again, quick disclaimer. I guess we're going to keep doing this. I'm not offering any
No,
legal
I'm asking
advice
like
or
from a
providing any
dad
legal
perspective.
strategy. But oh, from a
If your
dad perspective,
if your child told
oh,
you that your partner was physically harming them, would you discard that as a father?
uh, discard it? No, I wouldn't discard it. But me being me, I would be researching the law and trying to understand what I can do with child protective services. What could I do in the family court? What options are available with law enforcement, so that I understood what my options were.
So
Uh,
I tried to, before taking the steps that I've had to take, I've tried to clarify with dad what the child told me. And dad wanted to hear none of it. He immediately was like, the child is a liar. He's not telling you the truth. That didn't happen. And the child is adamant that it happened. I
it
wasn't there, but I believe my child.
well, and I believe your child believes himself. But being a parent, I also know that my kids sometimes say things that they believed happened and didn't. So I understand the need to be cautious.
Mm,
I also understand how quickly somebody can say, he hit me, and now the cops are involved, and somebody's going to jail for the night, even when they didn't get hit, right?
mhm.
Just the oral testimony. Um, it's a sticky area. But I can tell you that if you brought the matter to the judge, as you described it, the judge is just going to say there's no license for parenting, right? He can do what he wants. Dad can do what he wants to do. He can live with whoever he wants to live with. That person can say and do whatever they want to do, as long as it's not uh, causing particular physical, psychological, emotional harm to the child. And in that case, you can't just assert it. There has to be an investigation. There has to be evidence of that injury to the child. So it gets really muddied. I know that's something that we're working on here in Florida, because the law is actually very clear in Florida since 1983, but the agencies don't enforce it because they're looking for what they call actual injury. They're not willing to take into account that the law has clearly said for decades that invisible injuries are also abuse, are also harmful to the child.
I just wanted your perspective as a dad. Thank you, though.
Oh, you got
Hey,
it. Yeah, I mean, this all makes us all enraged. It all makes us very mad to think that this person who we had children with aren't protecting, or don't have the same sense to protect the child as much as we feel we do.
Right.
Yeah, and Aubrey from Another Parent's Battle, she says that was the abuse report to CPS, and if it's unsupported, if CPS won't remove the child, courts won't. So, I mean, yeah, just take the legal stand, fight that you got to do to protect your kids.
Yeah.
Well, thank you so much for tuning in and joining the live tonight. All right. Now we got it. We're going to invite in a father's fight here. He's requesting to jump into the live real quick. Again, just go ahead and push that out. We're not giving legal advice. We're talking to Chris Felder. He is a candidate for the House District 74 representative in the state of Florida, and we're helping you understand the laws, how they're broken, and what we're doing, and what he's trying to do to get those fixed, to make change, so that other people don't have to suffer the way that we have suffered in the past, and we're trying to make that a change. Let me see if the Father's Fight's still in here. I don't know if he's still in here, but he requested to be in. Let me see. I don't know, but if you have any questions, you don't want to jump in, just go ahead and put them into the comment section. We'll try to get those answered for you as well. Chris, let's go back here to, I guess he jumped out of the live, so maybe they'll come back in. Sue, thank you for tuning in. Mama of F4, thank you for tuning in. Aubrey says, can he speak more upon why so many use the term corruption and what it might be instead? And I think I might have touched on that a little bit earlier. And why it can hurt your case to use the term corruption. Why can you hurt your case if you use that term?
Well, certainly we tell all of our advocates to not use the C word, as we put it. As much as you may see corruption, as much as you may believe there's corruption, and I think you said it very well, Scott, that the judge isn't necessarily on the take. They're not making money off of your misfortune. They're not getting promoted, obviously, based on your misfortune. But there is often corruption lower down on the food chain where you may consent or even request for a guardian ad litem, a parenting coordinator, a social investigator, a supervised a visitation supervisor. And those people belong to these little networks where those networks, they could be LLCs, they could be 501c3s that only exist for the financial benefit of their members. So yes, there's a lot of corruption in that space, just to be clear. But as advocates, it doesn't make any sense to walk into policy leaders, whether it's legislators, members of the judiciary, sheriffs, police chiefs, school principals, and walk into the conversation saying you're corrupt. You're going to immediately alienate the very audience you're trying to influence. It does make more sense, however, excuse me, to use words that are a little less charged, but mean the same thing. You can say there's deceit. You can say there's apathy, learned helplessness, incompetence, dysfunction. When these are elected people, that's what they ran on. They ran on that they were less dysfunctional than the other guy or gal. So you can use their language. I just wouldn't use the C word. One, because I think it's inappropriate. It's not the right word. But again, because it signals the wrong thing and immediately puts them on the defensive, as opposed to, again, what we're trying to get done is corrections to the system. I hope that answers Aubrey's question.
Yeah, one thing, Chris, that I've kind of come to terms with is also is that the courts are overwhelmed. They are overwhelmed, and some of these judges don't even look at the evidence until a couple of days before, if they even look at them before a case management hearing, until the day of that morning as they're getting ready. Some of them may not even look at the evidence and know the whole story because they have so many cases they're looking at day after day after day. They don't remember what they saw you last time. They don't remember what was exactly. They have to look and refer to their notes and exactly what's on that. They don't have this memory to where they know exactly what's going on. So it's very important that when you do go to court, that you're clear and concise on what you're trying to convey to those judges, so they can get the whole picture and have your thoughts collected and not go in there rambling, because they're not going to understand anything.
Absolutely. And I'd say every motion that I write, I recap and just remind the judge that this is what's on the record. These, here I can show you this person was in contempt, this date and time, this date and time, this date and time. I go through the whole thing. You can't assume that they remember And also, it may surprise you that just because things are in the docket, they're not technically on the record. So sometimes you have to bring them, you have to make mention of them again to get them technically on the record. So again, just because it's in the docket doesn't mean it's on the record.
Yeah, thank you for just joining in. We're talking to Chris Felder, candidate for Florida State House Representative District 74, Sarasota. I know the Jeff, the investigator we talked to last week, Chris is back in the chats, and he says, and your attorney may not only look at you on the courthouse steps the day of the hearing. That, you know what? He's 100% right. Let me tell you, before my first case management hearing, I filed contempt charges in July of last year. It took until February to get to court, and I was once I finally got that court date, I didn't know what was going on. I didn't know what a case management conference was, and I was just like, all right, so what are we going to be ready for? I'm going to show my evidence, and he was just like brushing me off. He literally told me the night before, as all week long, I'm trying to tell him, hey, what do I expect? What can we do? What are we going to be doing in court? What can we push for? He called me the night, or texted me the night before. He said, I will call you in the morning. The morning before court on a Zoom call, he told me that he would call me in the morning. I'm happy to say he's no longer my attorney. So, and that's just, he's absolutely right with that. Was saying that sometimes, your attorneys are just as busy as, they're fighting so many other cases.
And if I may add to that, and I'm guessing our friend, the investigator, would second this, that as soon as you have an inkling that your lawyer may not be the right person to represent you, isn't the best advocate for you, my best advice is that's the time to shop for another lawyer. Don't string them on or think that, oh, well, tomorrow will be better, or maybe next week will be better because I liked them 2 weeks ago. The idea is that once you have that feeling, you need to trust your instinct. You have that feeling for a reason.
And I'm not saying that all attorneys are bad. I'm not there. Some of them are
that's not
very,
what I'm
very,
saying
yeah. There are very great attorneys out there. You just got to find them. You just got to find the ones that are hustlers, the ones that are going to work and just not stop at 5 o'clock. Would Chris support Bill's solutions that are gaining momentum in other states? This is from Brian, Family Advocate, MD.
Such as?
He says in Florida.
Brian, you want to jump up here?
Brian, you want to jump in? Just give us a yay or a nay, and I can invite you into the live. We'll give him an opportunity. I'll just see if I can just. He's in here. I'll try to swing him on in. I think he might have dropped out.
He dropped
you know
out.
What?
You just throw a question in and leave? That can't be.
The Jeff, the investigator, wants to jump in. Let's bring him in for a second. We'll get him in here. He's got some good insights because he was. We talked to him the other night, and let me.
There's Brian. He's asking about Robert Garza's time taken back and the 3 strikes. Brian, I hope you'll step up next. I'd love to discuss it if you're willing to come up and talk about it.
All right, we got Jeff Pike, private investigator. We spoke with him the other night, and he did a lot of private investigation for people experiencing parental alienation and other family court issues. Welcome in. What's going on tonight, Jeff?
Yeah, thanks. I appreciate it. No, like I told you before, I've been in the business 23 years, 16 years as a police officer prior to that. I do probably 20 divorces every year, probably 20 on top of that, child custody cases, which may not sound a lot, but it is a lot for a rural area like where I live in the rural Appalachia. I'm the go-to guy for the divorce attorneys in my area.
Okay. Yeah, so there's no shortage of business out there.
Yeah, well, I'm kind of the only guy with a good background as a expert witness and whatnot. So, but like I said, there's a misconception on the attorneys. I like what Chris said. A lot of people think I hire an attorney. You have to realize they work for you. You can hire and fire. I have watched many cases on the courthouse steps and the lawyers flipping through the file. And whether it's criminal, custody, divorce, whatever. I think a lot of people, and I always say, shop around your attorneys, do some checking with the clerks. What I have found that works is the attorney who, I don't want to be mean, or I know I don't want to be inappropriate with my wording. The bulldogs, the go-getters, the jerks, those are the people that seem to work in court. That's just been my experience.
Fighters.
Yeah. So
Yeah, you gotta fight in family court. That's the system they've created. I don't agree with it, but it's an adversarial platform.
yeah,
You have to fight to win,
and
and that's how the system's set up. There's a one winner and one loser.
exactly. And I have seen a change over the years, especially where I'm located in rural South Appalachia. The courts are tilted more towards the female or the mom or whatever. That has changed a little bit, but not a lot. I have had cases where the court has bent over backwards for the biological mom, even though she's had a lot of problems. And I used to explain to people there's certain courts that you would have to capture the mom on Main Street unaliving somebody before you're going to get results. And what they were doing was so over. I have been in court and testified about moms, and I don't want to pick on moms because it happens both ways, but majority of the time it's moms, where the moms are doing something so over the top, and the judge goes, well, it's the mom, and well, it's the mother of the children, when it's like over the top.
Agreed.
And I'm talking using illegal substances, man to man, couch to couch, no food, unattended children. I'm not talking about some very minor stuff.
Yeah, I just want to say thanks to some of the people coming into the live. Mama of four is in. Thank you. Hubert 6 is in. Dorsey Pruder, thank you for staying in. And Maddie's in here on the live too. If you would go ahead and like and share this live, get it out on the algorithm so we get more people in here. Jeff, let's just, if you have anything else, I think we got a couple of other people that want to. Is Brian still in here that we want to jump? He wants to jump in and talk about the Robert Garza bill.
Yeah, no, that's fine. I just I appreciate you invite me up. I deal with this other than an attorney day to day, and from a practical sense of what works as far as an investigator goes. Some of the cases, of what they want me to the information they want me to gather. So I appreciate you invite me up.
All right, yeah. And let me ask you a question:
Jeff.
Is it the courts that do it, or is it the parents themselves?
It depends. If I'm doing criminal stuff, I do a court-appointed criminal work. But it's mainly and I have my little sayings. Here in my area, I have a lot of what I call the grandparent cases. Grandparents in Virginia have no rights, so they have to show if something's going sideways or wrong. To get some type of rights in Virginia. But it's mainly referrals, and I could be directed by the attorneys. Sometimes the attorneys, I just deal strictly with them. Sometimes the attorneys will say, Jeff, I want X, Y, and Z. You deal with these people, get the information, and then they go from there. And if they want me to focus on one thing or the other, I will do that.
All right, Jeff, thank you so much for joining into the live. We appreciate you being here and tuning in, and we'll see you on the next one. All right, bud?
Okay, brother. Thanks.
Thank you. All
Thanks,
right,
Jeff.
let's go ahead. And let me just to get Brian in here real quick. Let's see, I'm trying to figure out how to drop somebody out of here.
I'm trying to get out myself, Scott. Sorry.
That's all right. Let's see. There we go. All right. Let's get Brian in here. He's going to talk to Chris about this bill that he was talking about. Brian, welcome in.
Hey there, Brian.
Good evening, gentlemen. Thank you, Chris. Thank you, Scott.
Hi there. Family advocate, MD. Where are you in the country?
Maryland, MD.
Ah, okay. I didn't know if that was for
That
medical
doesn't mean
doctor.
medical doctor or not. Real
Yeah.
quick, before we get started, Brian, just want to thank everybody for joining into the live. Jackson's dad, thank you for tuning in from in New Zealand, I guess. He's fighting for five years of fighting for family court. We're here to talk about comprehensive reform and a bill that Chris has got set up to push out the legislation here in the States. We're taking your questions. We're going to give people about 3 to 5 minutes so we can get as many people in here and get a little different perspective. And at some point go over some of these statutes that are broken and that need to be changed. And Chris has got a comprehensive problem versus the fix, and we're going to get to that. But go ahead and keep liking this live and share it out to the algorithm. Let's get more people in here so we can get them educated and aware and empower them with knowledge so they can help them, and also how to inflict change within the laws in their legislation. And let's do that. So Brian, go ahead.
Yeah, I'm actually working with Robert Garza, so that's why I brought it up to see if, obviously you've come across it yourself already.
Yes. So pick one. Which one shall we start with? Should we start with the time taken back?
Well, I think time taken, time back, and 3 strikes kind of go hand in hand, but either or.
Well, I would separate them entirely. So the time taken back, Robert Garza's sense is that's when the state is taking the children away for a custody matter. That in Florida would be under Chapter 39 when the state is investigating allegations of abuse or neglect, etc. We have a time taken back statute in Chapter 61, which is when the parent is the one denying the custody. And that's statute 61.13 subsection 4C. So I think when Robert sent his draft for the time taken back, it accidentally had even the wrong chapter in it. But the short answer is we already have it under Chapter 61. We don't have it in Chapter 39 when the state takes away the custody because it doesn't really exist in Florida. It was challenged in 2006 as unconstitutional. If the state were to get involved and essentially deny custody while they were doing an investigation, it was denying somebody their due process. It was challenged for its unconstitutionality, and it was the court declared it unconstitutional in 2007, and the state legislature replaced that law in 2010. So that's one that it's not a problem in Florida. So I enjoy sharing that. It's not a problem in Florida, and that's the reason why we're not trying to advance that particular issue in Florida. The 3 strikes rule is a different one. Did I satisfy your curiosity with regard to the time taken back?
Indeed. I was
Did I answer
unaware
that?
that Florida. Yes, I was unaware about Florida already having that.
It doesn't mean that we don't have problems, right? The agencies in Florida still behave badly. And when I say badly, I don't mean that they're doing it with ill intent. They just don't understand what they're supposed to do. And when I tell you, like all day, every day, I'm researching this, trying to understand why they're not following particular laws, trying to find case law that would somehow justify their behavior. I'm trying. But that's one of those issues that doesn't seem to be an issue in law. The next step would be making sure that the agencies that foul it up are held accountable so that they don't make mistakes. That again, that's a different issue, but same concern. The 3 strikes rule. So in Florida, and I would encourage you to check out the law in Maryland. It says any person with lawful authority, but it doesn't define what lawful authority is, and that is a problem. And it says the same in Texas law. So that is a problem unto itself. I believe that what is meant is whom has lawful right. Lawful right is different than lawful authority in legal terms. But let's not get stuck on that. Let's talk about some of the other stuff that's subjective. It says in Texas and it says in Florida that if a person acts with malicious intent to deprive the other parent of their lawful custody or visitation, they've committed a crime. That is subjective. It would require the police, it would require the prosecutor to prove the state of mind of the parent doing it. One issue I have with the three strikes rule in Texas is it does not resolve that concern. It doesn't address that subjectivity. It was like the legislators just glossed right over it. It was not fixed. So I would encourage you to check that out in Texas, check it out in Maryland. You want to change that language in the statute to say with disregard for a court order, right? Or with disregard for a person's lawful custody or visitation by statute, by court order, by agreed to parenting plan. Right? You want to remove the subjectivity out of that part of the statute. Similarly, Texas and Florida have what's called an affirmative defense. And let me see if I can remember the one in Texas. In Texas, it says something to the effect of if we'll call it this person, the abductor, if they are abducting the child because they believe that there will be I think they use the word commissioned act, that if they believe that they or the child will become a victim of domestic violence, and that's the reason why they did the abduction, then the law shall not apply or does not apply. So that's an affirmative defense. That language is what's keeping your Texas statute from being enforced. Same in Florida. That's what's keeping the law from being enforced. In Florida, it says if the abductor believes their actions are necessary to preserve the child's well-being, the law does not apply. That's what's keeping the law from being enforced. And so that's a significant thing that needs to be changed. Where the three strikes rule, what it does effectively is it knocks down the crime from a felony to a misdemeanor. Because in Texas, all felonies are reviewed by the grand jury. And the grand jury was not, my belief is that the grand jury was knocking down these allegations, and meaning they were dismissing them, not because of the level of the crime, but because of those subjectivity issues that I mentioned a moment ago. So knocking it down from a felony to a misdemeanor, while it gets away with, now you don't have to go through the grand jury, it doesn't satisfy the fact that the other parts of the statute need to be corrected. Florida, our felonies don't have to go before the grand jury. They all just go straight to trial. So that's not an issue that we have to work through. To me, if we can't get the first crime enforced, why would we create the obstacle of having it? You have to get it be a misdemeanor twice before it gets to a felony. Our objective in Florida is we just want it enforced. And I'll tell you, to be honest, Brian and everybody else here, I'm perfectly comfortable with it being knocked down to a misdemeanor. I don't think that my children would benefit. I think it would hurt me if my ex was, had a felony now on her record because of this. I think that if a misdemeanor is mandatory jail time anyway, it's 10 days jail time. I think that's all the wake up that anybody needs, right? You get a punitive penalty, you're hit with a financial fine, and you get 10 days in jail. I think that's all anybody needs to make sure they don't do it again. But I wouldn't think that if you can't get it enforced the first time, that you should make it harder by telling somebody that you got to get it enforced 3 times. So that,
Okay.
Yeah.
You know where I'm coming from when I say that, Brian?
Yeah. Yes, I do.
So those are things, and you said you're working on this in Maryland. Those are things I would look out for, and I'm happy to work with you on this offline and point out those things in the statute. But you got to find those things that are subjective, get those removed out of the legislation. In Florida, I believe the subjectivity was added in 1988, and that is because there was a domestic violence movement across the country. But when we got our own domestic violence legislation in 1994, nobody ever went back to this 1988 custodial interference legislation to correct that loosey-goosey stuff. I hope that helps.
Yeah, thank you, Chris. And thank you guys for shaking the tree to bear better fruit for everyone.
You got it.
That's right.
Thank you for your
Hey,
support.
thanks.
Yes, sir.
Thanks, Brian. If you just joined the live tonight, thank you so much for tapping in. If you want to have a conversation, if you want to talk to Chris, if you have a question to ask, we're happy to put you on to the live tonight. We're talking to Chris Felder. He is a candidate for the Florida House District 74, that's Sarasota area. And he has got a comprehensive bill that we're going to be pushing for legislation. Because even if you're not in his district, I mean, we can get this out to your representatives and they can jump on board with it too. So when they do go to legislation back in about 6 months from now, they can all be talking about exactly what it needs to do. And if we can get enough voices and enough noise, then maybe they'll start caring and it'll start mattering for this issue. And we can start, like Brian just said, shaking the tree in there and just getting some change made. Alicia says, Chris, can you explain what you want to replace the belief with and why belief is too vague?
Well, in and of itself, hopefully if it isn't clear, just the idea that you can't get into somebody's head, right? A prosecutor, a cop, they can't get into somebody's head and prove that somebody was believing anything. So shy of the perpetrator saying into the sheriff's deputy's body cam, I'm doing this with deliberate intent to deprive Brian of his parenting time. And I'm doing it because I don't like him, right? Shy of that, the cops are just like, we can't prove what's going on. And again, this is very sloppy language that's been allowed to be put into every state. I have not found one state. It's there. Every state's it's written differently, but they all say effectively the same thing. That if the person who's abducting the child thinks that they're in the right, the law does not apply. And so naturally you ask, so then how was it ever enforced? And I would say not because the cops brought it in. I would say it's because there was a different crime that was committed. The prosecutor had it all written up and was taking this person to task for it. And then they were like, oh, you know what? This qualifies the custodial interference statute. And they attempted to press charges for that violation as well. But it wasn't why the cops picked up this person. I hope that helps with that. If now's a good time to jump into the letter, because I think that the conversation with Brian's a good stepping off point to get into the letter.
We can do that. I know you're preoccupied. We got Dorsey who just jumped into the live real quick. Hey. And if you're watching this on your For You page, and if you want to hop into the live, if you know somebody that's going through family court, it's a painful thing, and it's not really like some people are saying. It's the C word, the corruption. It's not really that. Just that the laws are flawed, they're outdated, and they need to be updated to really help support the judges and the system to help better officiate, to really heal, and so everybody comes out a winner. And we need safe, comprehensive change in those languages, so that way we protect from false allegations, we get faster resolution, and we get through the process, because that time between the first contempt charges and through to final trial, it's just more hurt and pain for the children who just develop anxiety and more fear and more just being used as weapons. And the quicker we can get resolution, the better. And if we can just make it safe for everybody is what the mission is. Dorsey, welcome in. Go ahead and share this page out to everybody. If you have a question, we're going to give you a couple of minutes to talk to Chris. He's running for candidate for the District of 74 in the Florida State House, Sarasota. And we're going to get to his letter in just a second. We'll take one more question from Dorsey, or if you have anything to say, if you want to ask Dorsey, you can pop your questions into the comments. And I'm sure she's got some things that she can share with you.
Hi, Dorsey.
Hi, Chris. How are you?
Great. You?
Great. I'm doing awesome. Thank you. Thanks for inviting me, Scott. This is great.
Yeah,
great live.
Thanks for coming in. Thank you.
Yeah. So love what you guys are sharing. I love the C word. That's pretty funny. Yeah. I coach clients that deal with alienation all the time, all over the world, and teaching them how to use the right language instead of using parental alienation, actually using child psychological abuse. And we've actually are on the precipice of launching an app for frontline workers, for police officers and guardian ad litems and child protective services, to actually use a very simple tool to ask certain questions and enter the questions and how the person answers to determine what is going on in their head. So kind of what you were talking about, Chris, but the psychology behind or the pathology behind this family dynamic. So you're right, the laws are outdated and families are stuck. The domestic violence has run amok, and we've been looking at data and evidence from a complete family dynamic. So the whole picture, from whether there's an allegation of abuse or alienation, there's generally something going on somewhere in between, and looking at all of the facts. So a lot of what you were saying earlier about hiring a lawyer, they're very expensive mouthpieces in family court. And we tell our clients all the time, what you put into the mouthpiece is really important. So if you're waiting for your lawyer to make decisions for you and present your case, you're doing it wrong. You need to be able to give them the data in a very clean, concise way so that they can prove what's going on in your case. Sometimes you only have 5 minutes. And so it's really, really important to not wait for the professionals to figure it out, but for you to put your case together or work with somebody who can actually help you put the facts together properly so that you are stabilized, emotionally stabilized, and can put your facts together in a way that's easy to understand. But talking about alienation, Chris, I do a lot of cases in Florida. I actually love working in Florida because they have a law on the books right now for child psychological abuse. And so, which is great if the clinicians would diagnose properly and use proper terminology like child psychological abuse, then go ahead.
It's essentially not enforceable, though. So as much as you see it on the books, it requires that an expert witness be called in, and that's not for you or me as a litigant to call in the psychological abuse specialist. It has to be called in by Department of Children and Families or the state prosecutor, and they won't call in an evaluator. So it is another one of those examples that's just impotent. It's on the books and it has no effect whatsoever.
And just real
There's
quick,
also definitions for. Go ahead.
Yeah, just so I can just chime in there too, because during my case, real quick, is that the fact that my former attorney was telling me, hey, we need to do a social investigation. It's going to cost you about $20,000, but I think it's something we need to do. And I'm like, who's got money to like, and then that's just the beginning. He said, it could cost you way up more than that. He said, unless you're a billionaire, I wouldn't really suggest doing it. And you have a lot of money to throw at them. But he was pushing for it. He really was pushing for it. And who does that help? That doesn't help anybody. That just deters people away from getting real comprehensive medical evaluations.
That's true. The social evaluations or social investigators, those things are abomination. And they're just oftentimes hit pieces and opinion pieces. And it's like, he said, she said, he said, she said, he said, she said, the kid said, okay, and then we're going to leave things the same or get a reunification therapist, which there's no such thing as reunification therapy. So families go to therapy that with incompetent mental health providers who only make matters worse. And so you get duped too, oftentimes as parents get duped into a therapist saying, oh, I know what alienation is. And then they go to these supposed experts, but they don't know how to solve the problem. So they also make matters worse. And it is a child protection issue, not a child custody issue. And you need to be working with somebody who understands that and can work with the professionals in your area to get them to understand the child protection laws and to use them. So we do a lot of work in Florida. And while you're right, Chris, the law on the books is just that. You have to be working with somebody who understands how to work through that law to get it to apply to your case. And it is an uphill battle. I mean, we've just trained a whole bunch of mental health providers and, it was like, to train them on how to actually assess, diagnose, and properly protect kids. But then you also are running into, like Chris said, Child Protective Services, who also is unbelievably incompetent in most jurisdictions. So it's getting your narrative properly written and your evidence organized in a way that it's indisputable. And it's very easy to fall down the rabbit hole of parental alienation or domestic violence. And oftentimes it's an either or, and it really isn't. And people get really caught up in the emotions of this family dynamic. And we're all surrounded by unbelievably incompetent professionals on all levels. And not all of them, but a lot of them.
Yeah. Amy, thank you for joining the live tonight. And just real quick, Dorsey, if I would like for you to, I mean, we're going to talk to Chris and we're going to get his, some of his comprehensive bills. But if you don't mind hanging out for a little bit, some people might pop in some questions in the comments while we're talking about that, because we definitely want to talk about the legislation and the letter that he has. But I definitely think that you also have an expert opinion that could probably help out some people that might be viewing tonight as well, especially on the emotional side of this and what they're dealing with family court. Go ahead, Chris. I didn't mean to cut you off, but if you're out there watching this, go ahead and tap that like button, share this, get this out on the algorithm. We're helping families tonight, empowering them with knowledge, what the statutes are in the state of Florida, how they're broken, and what Chris is going to do to fix them. And we got Dorsey joining us too as well. If you have a question for her, just leave one in the comments, and we'll try to get those answered. So that way, if you're hurting in family court, she might be able to help you in a different sense to kind of in that direction of parental alienation. Thank you, Tammy, for the antipasto. I guess that's what she's throwing up at us. And all right, Chris, go ahead.
Where was I? I think I was thinking about psychological abuse still. So I'm going off of memory, but I think it's only mentioned 3 times in Florida legislation. It's under 39.01 subsection 2, subsection 37, and then 827.03.
You're like an encyclopedia. Sorry, but you just how you can recite these knows that this is a testament to your knowledge, and it's great that you're putting these bills out there because just how you can recite these statutes. I know you've been doing it for a long time, but for everybody listening, I mean, when someone can recite these, you know that he's studied this for a long time, and what he's talking about might just help us change it. So make sure if you're in Sarasota, you're listening. He's going to be running for representative. Vote for him. Push his letter out to your legislators and to your representatives so we can get these bills passed. I'm sorry, Chris. Just wanted to acknowledge that.
Thanks.
Continue on.
Thanks for the props. And I'm no Doogie Howser. I'm certainly no Rain Man. It's only because I've read these statutes so many daggone times in my own case and helping others, again, not offering legal advice or providing legal strategy. But in those, the reason why I was bringing up that distinction is under Chapter 39, it's for dependency court. It's when CPS would be involved in removing a child potentially from a home. It's that legislation as well as 827.03, which was criminal justice. But neither one of those would necessarily be permitted to be used in your family court case. So I guess what I would share with the audience is the word psychological abuse, you may have to frame it differently, right? You could call it, significant emotional impairment or something. But if you're going to use defined terms from legislation, it could get you, perhaps stepping in an area where the court feels it doesn't have jurisdiction. So just kind of throwing out ideas out there. It's one of those things that you just have to understand well the jurisdiction that you're in. You talk criminal justice statutes when you're with the criminal justice community. You speak of Child Protective Services statutes when you're in that community, et cetera. Right? You don't talk about the family court in your kid's school, except that you have a court order. You speak of the legislation that has to do, that which gives the legal framework for schools, right? So you have to understand the swim lane you're in when you're making these arguments. And you'll often see in the legislation, it'll say for the purposes of this section or for the purposes of this chapter, this means this. So you can't necessarily cross streams and think that because I saw a word somewhere, it must mean the same thing somewhere else.
So National Family Justice and anotherparentsbattle.com is sharing the link tree to Real Chris Felder. If you want to see these statutes that he's talking about, the problems and the fix. What was the one you were just talking about there? Was that 39.301?
827.03? Or I'm sorry, 39.01. 39.01 is DC, Florida's Department of Children and Families.
Okay.
39.01, and if you're looking at subsection 2, which is child abuse, and subsection 37 is child harm. And under both of those, I believe it says psychological
definitions
harm
exclude
or injury.
Yeah, definitions exclude alienation or emotional abuse from parental interference. That was
from my letter, right? Saying that it's missing that.
Right. And so the fix is emotional harm from interference with a parent-child relationship is a violation of a court order. And it feels like it's already in there. It's just it's not strong enough.
Are you
But
saying?
go ahead,
Can I
please,
ask you a
Darcy.
question? So are you saying it says? Are you arguing that it needs to say parental alienation?
No,
I
I
didn't
think
use
you
those
said
words.
no. You said emotional harm. That what we need to do to fix it, to add it to that, is emotional harm from interference with a parent-child relationship is a violation of a court order.
But child
That is the fix.
psychological abuse, by definition, is parental alienation or interference between a parent and a child relationship is child psychological abuse by definition. So if the child has the symptoms of rejecting a parent, an attachment system disorder with a normal range parent that they had a relationship with, and there's no viable reason for that, then that one thing alone is the definition of child psychological abuse. If the child has the fingerprinting of a personality disordered parent, they're haughty and arrogant, they're rejecting a parent, they're splitting, one parent's all good, the other parent is all bad, they have the symptoms of a pathology that they can't be diagnosed with, that is a diagnostic symptom of child psychological abuse. And then the same thing with a fixed and false belief. If the child believes, let's say, Chris is abusive, but the evidence supports that he's not, then that is a delusion. And that, by definition, is caused by something. Is it mom, is it dad, or is it both? And so child psychological abuse, the definition and what's used, and actually, Chris, in Florida, I've worked on cases where the treating mental health provider diagnosed child psychological abuse and recommended a child protection order in the family court and a reverse, at least temporarily, of custody, multiple times using that child custody, or that child protection law.
Child psychological abuse is the way you're framing it. You're saying by definition, it's not defined in law. So
Got
I
it.
believe you're referring to the DSM-5,
Or the
and
ICD.
certainly I've reviewed Dr. Childress's assessment and all that. I'm pretty, I think, well understanding of his perspective on that, but it's not in Florida law. So what I was saying earlier, which I
Got it.
think is where you're going with this, is that
Right.
you have a mental health professional on the stand providing expert testimony, and they're saying this, in his view or her view, is child psychological abuse, but it's not defined anywhere. So it's being presented to the court as this is harm, this is detriment to the child, which is under it's under the I want to take my words back because I said a word I didn't want to use. Under 61.13 subsection 3, A through T, it speaks to the child's best interest factors. So
Right.
in there's a fair amount of emotional issues, right? If you have to provide the right environment for the child, and there's a standard of evidence. The burden is a preponderance of evidence. On
Right.
the other side of this wall is Chapter 39, which is Child Protective Services and the safety of the child through their lens. And that's where you see the term psychological abuse. So there's the
Got it.
same judge has purview over both of these chapters of legislation, but you're in the courtroom talking about Chapter 61.
Got it.
And if you're going to call over here to Chapter 39, the assertion is that it would be detrimental for the child. That's a charged word. It would be detrimental for the child to be with this parent. And you're essentially asking the court to suspend or permanently terminate this parent's access to the child. But I'm just trying to, when you, and I don't mean to pick on the word, except to be clear, it's not.
No, I was asking for clarity, so thank you.
The psychological abuse, yeah, when you said it's by definition, it's not in a legal definition. It's in the DSM-5 definition.
Right.
And I'll tell you that where the only place where I've seen the DSM referenced in law is in and I'm sure it's not the only place, but it's my guess, is in the Americans with Disabilities Act. I haven't seen the actual manual referenced anywhere else.
Interesting.
Hey, Maddie from the Anti-Alienation Project is asking a question. She's saying, Dorsey, what is your opinion on having more mental health experts access children in family court?
What is my opinion in having mental health
more
access? Ugh. Well,
Eh.
no. Yeah, well, what my opinion is what would be phenomenal is having more properly trained mental health providers who know how to assess, diagnose, and treat mental health disorders surrounding this family dynamic. So I don't think we need any more mental health providers in family court. I think we need less mental health providers and more qualified mental health providers. So, and same thing with like guardian ad litems and minors counselor, whatever they're called in your jurisdiction, right? There's so many interlopers in the family court system. Everybody has their hand in the cookie jar and they're really not in it for themselves or for the kids. They're in it for themselves. And you know, the people that suffer the most are the families. And when you deal with this family dynamic, it's a whole family problem. It requires a whole family solution, but it's a child protection issue. So first we protect all abused children all the time, and then we re-educate, rehabilitate, and reintegrate when possible. So it's never the appropriate response to just eliminate a parent, even a bad parent. We want to protect the child from the bad parenting, and then we want to rehabilitate the parent's bad parenting when possible. And sometimes they can never leave a supervised type of parenting because they either refuse to get the help or they're just not safe for the child to be around. But in the end, you know, when we look at a whole family problem from a whole family solution, we get out of the elimination game and we get into the integration game and we say, this is family trauma, right? So unfortunately, most of the mental health providers surrounding family court globally, this isn't a local, this is a global issue, are incredibly incompetent and they don't understand the family dynamic, and it's polarized by domestic violence and parental alienation. And is it a real thing? And then everybody fights and, you know, falls down the rabbit hole instead of pulling themselves back out to say what's actually happening. And going back to the beginning of this conversation, or at least where I jumped in, the evidence, right? And how are you organizing and putting your case together so that the people who make the decisions can make appropriate decisions? Judges are the same as a mental health provider as far as the ability to protect children. So mental health providers can say this is child abuse and make a child abuse report. A family court judge can make a order for child protection and full or temporary, permanent or temporary change of custody based on evidence. They actually don't need a mental health provider to tell them what's going on. They've simply become very lazy in the last few decades in wanting other people to tell them what they need to do. But ultimately, a judge could make a child protection decision without a mental health provider. They just very rarely do.
And
I got two things I'd like to jump on, but go ahead, Scott.
I was just saying for everybody, thank you for just tuning in. I just want to keep people engaged and let them know that you can put a question in the comments. We're talking to Chris Felder, representative for the District 74 in the state of Florida. His comprehensive bill, that SAFE bill that I would like to call it, it protects everybody in the family. And Dorsey, who's helping out with the parental alienation and some, I guess, some aspects with that as well. If you have any questions, drop them into the comments below. We'll get those questions asked. I know a lot of people are hurting. And real quick, I just have a question about where you were just saying about getting the judges to just weigh on this, you know, and making decisions on what they can see is basically clear violations and evidence when you present exhibits and evidence into the court, like just straight out emotional abuse, text messages from the kids, from the other parents, that just becomes hearsay. And, you know, then it just gets thrown out. It's not valid. But why are we in the age of a digital where there is video, where it's so hard? I mean, why are we just saying that's not acceptable in the court anymore when it shows clearly that there's someone on video doing something? We're just going to ignore that.
Are you asking me or Chris?
Yeah,
I mean, like, is there any way? I mean, how come the judges, like you said, I mean, is this part of something that we can, you know, work on changing that? Where when
that's
it's
rules of
clear,
evidence,
right?
That's rules of evidence. That's not quite the same thing. It's
Yeah, I know.
because it's hard to understand the context of a situation. You could show a text message, you could show a video, and it's just an excerpt, or it's a moment in time,
Hmm.
and it could have been a call on something else. Or here is mom yelling at the kid because the mom is off camera before the recording started. She already said 10 times, "I said take your shoes off the kitchen counter." Right, and the part that's
Hmm.
recorded is when she loses her mind, which is within every parent's right to lose their mind and yell at their kids.
That's
Uh,
why focusing on the kids' symptoms is so much more important than the he said, she said. Family court is kangaroo court. They look at evidence that violates the rules of evidence all day long. Like judges make decisions to protect kids from false allegations of abuse. They're very quick to use that. When a child and a parent says, my dad beat me, and then Child Protective Services gets involved. There's a whole investigation, and it's unfounded. And it usually takes months, not days, to do that investigation, and the damage is done, right? The child is now fully cut off from a parent. The judge made a decision and it's supposed to be temporary. Now it's created the foundation for the way, custody is set, and it's nearly impossible to get out of that. And they look at things that aren't evidence all the time. So yes, it's the rules of evidence, but the kangaroo court and family court oftentimes doesn't follow the rules of evidence. Unfortunately, because I work all over the world, this happens everywhere. And so it would be nice if they actually followed the rules of evidence most of the time, but they oftentimes don't. And once they make a decision in family court, they don't want to unring the bell, especially when it comes to allegations of abuse, child abuse, or spousal abuse. And so even when the evidence is compelling or the investigation shows that it didn't happen, and I would say people would probably put this in the comments, that trying to overturn that is really, really challenging. I feel like that's where legislation really could help families, is like having an actual fair process in family court. And when an allegation is made and it turns out to be false, then the consequence of the false allegation should be as punitive, if you will, as the allegation itself, and then
but what's the
rehabilitate.
definition of false report, right? It
Right.
gets I'm sorry, I don't mean to interrupt you, but
Yeah.
we keep it coming up with, and nobody's saying, like, here's another buzzword, Scott, right? These are very poorly defined concepts in legislation
Hmm.
that we as lay people are going, hold on a second, they lied. Well, did they lie, or did they just present false facts? And you're like, what the hell's the difference? Well, there's a legal distinction.
Yeah. From a
And
legal
that's,
perspective.
yeah,
Yeah.
that's, if I may go back to, because I didn't have my opportunity to counter this, and Dorsey, I hope I'm not interrupting you.
No, please.
You
I jumped
said
on your
more
chat, so.
qualified and competent mental health professionals, and I have a different opinion on that. I think after all the time that I've dealt with this personally, and then being, I'll say, a leader in the reform movement in Florida, I've been speaking to people for the last decade about their personal stories. It's amazing. We're all different. We all come from different walks, different parts of the country, um, different cultural values, different religions, and yet we all go, "Oh my God, we were married to the same person."
Hmm.
These behaviors are so easy to identify now
Yes.
that I would say what we need to do is take all the mental health professionals, and with that, I don't mean just the social investigators, but I would say the parenting coordinators, the guardians ad litem, take them all out, because that's again where the corruption is. That's the what are they, what anyway, that's where the bad stuff is, and just narrow the legislation to call out and be specific. Like, if this person can't show up on time for custody exchanges, that's alienating behavior, right? If this person can't, interferes with your access to get school records, that's alienating behavior. Like, let's call it out. Why do we need to then pull in all of these experts to say what we already know is the violation? But when the legislation was written, it was like, hey, these are complex cases. We need to give the judge all of this latitude to make sure that they get the right decision. We now know we have decades of research and understanding, so much so that we can boil it down to like 4 bullet points. I would like to remove all of the best interest factors for multiple reasons. One, because I argue that it's unconstitutional to have these best interest factors. But in Florida, we have 19 best interest factors, and then one more for good measure that just says, hey, if we didn't cover it in the first 19, we got it covered in letter T. That's ridiculous. You're giving the court way too much subjectivity, which means the laws are vague, which means they're applied inconsistently. For what? Because so a judge can determine how your child should be raised. And that's unconstitutional, but it's wrong. So I'd love to see all of that very tightly, narrowly tailored, so that we move these things through the system quicker, and and children get returned. These relationships are preserved. As soon as you get that narcissistic or cluster B personality disordered parent who even when they're not losing, when they sense that they've lost, sometimes they just leave, right? They'll just leave the relationship altogether, or the child altogether.
It
In other
happens.
instances, yeah,
Yeah, it
not for
happens.
anything. The rest of us are going, what the hell happened? You didn't lose. Why are you so upset? But that's the way they think. And it happens often enough that, again, I think that we can tailor this. Um, uh, I don't want to name any names. So Scott will say there was a dad I was talking to who said, I got a feeling that I should just step away. Dorsey, this is a good question for you.
Okay.
I should just step away and give some time to the case, because I'm afraid that between now and my next court appearance, that every time I try to interact with my children, it's giving the other party an opportunity to accuse me of something else. And my best advice at the time was, we actually have case law that says when you stop engaging, the other party can then allege that you've abandoned,
Yep.
and it now gives them the upper hand. Everything that you were trying to avoid, you've just played into their hand unwittingly. I don't know that they realize they're doing that. But do you have any thoughts on that?
That's great. So first of all, I agree. Less interlopers in the family court. I think we are on the same page there. Less is more. So that's when you mentioned Dr. Childress is one of the things I love about Dr. Childress's work is it makes it so simple to say what's happening to the child. If the child has the symptoms, then who's causing the problem? Is it mom, dad, or both? And then what are we going to do about solving it? And having a solution is mission critical. The more people with their hand in a cookie jar, the worse the case gets. You should never, ever walk away from your children and communicating with your children. You should always be communicating with them regardless of how they respond, unless there's a protective order. So if you have a protective order, please do not violate your protective order. But I agree with Chris that when the pathogenic parent is trying to get you out of the picture, the last thing you want to do is fuel the narrative that you've abandoned the children. And having been one of these kids myself, and I started my company out of my own childhood experience and understanding that there was no solution when I was trying to reunite with my dad and prevent this from happening to my own children. What is abundantly clear is that the people who follow my advice and stay in constant contact either prevent the pathology from taking hold or recover their kids. And those that like walk away and take a break and wait around someday or whatever, you're absolutely right. Some pathogenic parents will use it as an abandonment, and the kid still, your children love you. Your children love you and they want to be in relationship with you. So what they're saying and doing is not how they actually feel. And so it's very important to stay in communication. And it's also mission critical about how you communicate. So things like, I love you and I miss you, or asking, why are you doing, I'm so upset. And I just want to see you, that kind of stuff, any kind of needy energy the child gets triggered by. And then it's really important to pour into the child about the child. So unconditional love is more like, I saw you, hit a home run over the left field fence. Congratulations. I love you, Dad. Right. Or I found this amazing thing, made me think of you. I love you, Dad. So even if it's one-way communication, you should always be communicating with your kids because they love you and the bond is never broken. Even if you feel like it's broken, it's not. It's just tucked below the surface. They want to hear from you even when they say they don't. So it's really important. It's also important, if you don't have a protective order, to show up. Even if you're sitting in the back of the stands, let them see you there. Even if they get upset, or the upset emotion is the upset emotion of the other parent. They're like dumping their emotional trash into the child. So when the child gives you their emotion, they're emptying the garbage. And so I always tell our clients, put in a good smell good liner, let them dump the garbage and take out the trash. Don't take it personally. It's not about you. They're actually saying to you, you're my safe parent, and I know I can give you this garbage because I know you're going to take out the garbage, and I love you for doing that. Even if I can't say it now, please don't go anywhere. So Chris is right. You absolutely should stay present. And if you are upset or you get dysregulated by the emotion of it, which is completely understandable, work with somebody who can help support you in your own regulation, because the more regulated you are, the more grounded you are, the easier it is for your kids to fold back in. You want to be the soft, easy place for your children to land. And I coined the phrase the chosen parent because the child is choosing you. The rejected parent, they're not rejecting you, they're choosing you to help heal the family dynamic. They know that you're the healthier of the two parents, and they know it even if they can't say it, and they can feel it, and they always feel you. So regulate yourself, show up, be strong. Your children love you and they're grateful.
I don't know how to clap on this thing, but that was fantastic. That was very well said, Dorsey. Thank you so much. There you go. Scott's got all the sound effects.
And just for full context there, that was actually my situation that happened just yesterday when I went to go pick up my children from my ex. And there is a no contact order. And if y'all don't mind, I'll just go ahead, and I didn't want to, bring this up, but I think it's something very important that a lot of people probably understand and that may be dealing with this as well. So she's utilized a false allegation, had me arrested when I had my kids with me, and manipulated text messages because they were with me my first night. So we've been dealing with this, and I've been picking them up at the same location, which is at the school directly right outside of the community, but it's also backs up to the house that she still has, that I'm waiting to be sold for over a year now. But that's neither here nor there. So the father-in-law, my ex-father-in-law, would meet me at the school for drop off and pickup. There's been a lot of the kids getting out of the van and walking home and not staying there, and they're saying they're not going to go with me. The Thursday night, the night before this, I told them that I couldn't be there until 6 o'clock, and they said, or 6:30, and they said, no, you have to be here at 6 because we're going to dinner. I said, great, my sister will pick them up at 5:30. And they said, no, that's not allowed. It's not in the agreement. And I showed them that it says I have to provide transportation. It doesn't matter who it is. And then she said, no, we need 48 hours advance notice for any schedule changes. I said, this isn't a schedule change. This is written, and she likes to do this twist to her own definition. She did it for 2.5 months and blocked my parenting time after the holidays, saying that weekends were my weekends. So she was just trying to twist it up just so I couldn't, or my sister couldn't pick up the kids for me. And so this was the day before. And then the next day, the kids, they were very rude, telling me they hated me. They got out of the van and they walked home. And then I kind of went down the school parking lot because they were walking down the fence towards the house. And I wanted to see where they were going. And it was back to the backyard. Well, I just turned around and left. About 10 o'clock last night, I got a knock on the door. She called the cops saying that I violated the terms of 500 feet of the back of the house. Remind you, there's a wall, there's a fence, there's a spill off, there's another fence, and then there's a school parking lot. There was no imminent threats. It was just me picking up my kids, trying to see exactly where they were going. And she was, from what I understand, standing behind the house waiting for them as they were walking back to her. So she kind of, I don't know if she's, saying, don't worry about it. Just, you're right there, be outside the community. Just get out of the van and walk home, and you don't have to go with your dad, but you have to show up. And this is what they do every time. And it's been going on for 8 months now. And I think that I got a lot against her. coming up and how she's took the kids from me, tracked me down on a parenting app, threatened me with arrest if I didn't bring them home on my parenting time, that I am just now getting to show in court coming up in September. It's been over a year since I've had those contempt charges filed. And I'm fearing that she is going to utilize any way that she can to not face me in court. And that's what happened last night when the cops showed up at my door. Thankfully, the cops were understanding and kind of saw through it and realized that I wasn't a threat, that I was just there to pick up my kids and she suggested that I pick them up at the school, and I try to get that changed. And the court said no, because her parents are older and they can't, it's not good for them, whatever. That's just, they go all over the place. They travel. So it was just an excuse to get them not to have to go very far, and the kids can get out of the car and walk. So that's what I said. You know what? I might just for the next 2 months, I will still communicate with them. But at the time I told Chris, I said, maybe I fear going to pick them up now because of what she's going to do to try to have me arrested.
But Chris is right. You have to show up. So show up anyways, even if they don't get in the car, because they want you to show up. And even though it's stressful, everybody's like, oh, I don't want to upset the kids. I don't want them to feel we grow when we're in our uncomfortable, and it's only like this, we can't make anybody uncomfortable. It's like, it's fine if they're uncomfortable. They need to see you there. You need to show up and be mindful of your 500 feet, don't violate your restraining order, but, and keep just diligent records. Be very mindful of your mindset too. You said a couple of things, I'm fearful of this and I'm fearful of that. Focus on what you want. Like, really think about the outcome that you want versus the fear of what you don't want. And because your nervous system gets dysregulated and you are saying, this is what I don't want, but the universe doesn't know yes or no or do or don't. So just focus on what you want and what does it look like? And what is it going to look like when you go to court and you get the outcome that you're looking for? And when you start envisioning that, write it down. Like, what does that look like? And focusing on the facts, not the emotion of the facts. Because one of the things parents oftentimes do is they get in the emotion of the evidence. And I have this and I've got a lot of things, and it becomes very emotional, of course. So I'm not saying don't be emotional. Of course you're emotional. These are your children and this is happening and it's awful. But sorting the facts from the emotion and then really being clear and picking the best facts and putting it together in a way that shows and tells the story based on the facts and not emotion. Because if you go into the court with a lot of you don't want to be cold, but you also don't want to be, emotional, if you know what I'm saying, like talking about the emotional pieces of it. It doesn't go over well in family court. So you want to stick to the facts, and these are the facts, and keep it simple. You may not have a lot of time. So if you can tell your story in a short period of time, focusing on what's happening to your kids. So this is one of the things I think a lot of parents make a big mistake in, is they start talking about themselves and I'm the dad or I'm the mom and I'm this and that. Of course. Right? Of course. However, in family court, you want to be presenting your facts on how it's harming the children and the impact on the children and the importance of the children having both parents in their life, and that you're not trying to eliminate mom, you're trying to solve this problem. However, mom is unhealthy. Your situation, based on what you've shared, mom is actively trying to eliminate you and finding every way to do that. Another thing that happens in these false allegation cases is this is oftentimes a trauma reenactment. So she may have had childhood trauma that was unresolved, and now she's projecting it into your current family system. And she sees you as the perpetrator, and she's come to believe that to be true. So sometimes we think, well, she's doing it to be malicious and evil. She may actually believe this because she's in a trauma reenactment. And I think this gets played out a lot, and people don't understand it. And so removing yourself from that and looking at it through that lens might be helpful for you, especially when you're looking at the facts and less emotion about your situation. So of course, this is emotional and you should be emotional. These are your babies. So I'm not saying you should not be emotional. It's just using your emotion where it benefits your family and helping them recover and keeping it out of the family court system. That's my 2 cents.
Dorsey, we need to set a different night just for you can help people going through this and another time. And thank you so much for joining in tonight. And if you have any questions, go ahead and just put them into the comments, and maybe she can try to answer back to you. But go ahead, Chris.
I was gonna, I guess, my response to that, and I'll speak to you, Scott. It's very important that you learn the psychology, right? This is the way through this. You and I have talked offline about it. From my own experience, it just got worse in my head. It got worse and worse and worse until it didn't, right? Until it got better. So it's very important to understand the psychology for yourself and for your children, to understand what your children are going through. But something that I think many of the advocates who insist on stopping there and only understanding the psychology, they get stuck on this, like, but this is the way it's supposed to be, and this is the way that saved the children. This is the way, and you can be righteous, or do you want to win? And so my thought for you and the audience is, to all these things that happen, you have to learn to frame them as legal arguments.
Beautiful.
It's not just that, Your Honor, the child is being victimized, the child is being harmed. You have to frame it as a legal argument. I know you and I spoke informally about this, where you're presenting an emotion, the problem. Here's the solution, the relief I'm seeking, Your Honor. And here's the authority that you have to grant me the relief I'm seeking, right? The statute, the case law, the judicial rule. But as you get better and better at developing these legal arguments, and you're a very smart man, so I'm sure you're already thinking 3 steps ahead before I get the words out of my mouth. But that's where you're going to start thinking toward winning these arguments, not just trying to understand the psychology.
Yeah. And it's a dynamic that everybody that's going through this, and that's another reason why we're doing this, because if we can empower people with the knowledge, it can help them bring it all together, relax, calm down, realize that there is a strategy to it. You just need, and a lot of people with attorneys, I hate to say this, but they just feel they're muzzled. They want to speak, but they can't, because the court says you have a representative, they have to speak for you. And I know it's frustrating for a lot of people. And sometimes getting some outside help and some psychology help and understanding the laws and it's so great. And I think that's what we're doing here tonight, is helping a lot of people understand that. Dorsey, real quick, where can anybody, if they just like her page, if you have any further questions, where can they find you? For any advice, or just follow you?
Yeah, follow me on TikTok. I've only been TikToking for a couple of months, so. I'm on TikTok. So I'm on all the socials as Dorsey Pruder. And then my company is Conscious Co-Parenting Institute. So you can check out our website. We have tons of free resources and paid resources, but a lot of really free stuff and a lot of great free stuff. And my YouTube channel, I have hundreds of videos on dealing with this family dynamic, everything from the psychology of it to the legal stuff. I'm not a lawyer or a mental health provider, but I work with a lot of them, and I work in a lot of cases. I am a reunification specialist, so I actually recover kids and get court ordered to reunite kids after protective orders. So I've done it a lot and been doing it for almost 20 years in February. And so that's how you can find me.
Well, thank you for your service.
Yeah, thank
Absolutely.
you. Thank you for letting me pop on. This was so great. You invited me. I was like, oh, this sounds like fun. So thank you. Thank you, Chris, for letting me jump in and poke my head into what you were talking about. It's amazing.
You got it. You got enough to share. I'm surprised you don't have your own show, but I'm guessing that's coming.
We do. I have a show coming out with Maddie, actually. We're getting ready to drop a podcast in a couple of weeks. So Maddie from the Anti-Alienation Project. So we are just about ready to launch a podcast.
Oh, that's great.
And I'd like to understand from the perspective of the child. And I like you, I'm also the child in the situation. And then I got the joys of being the parent in the situation later in life. But
that's common.
I'd like to understand your perspective.
Yeah.
When you confer with Maddie on how state legislation could help children who are going through this.
Awesome. Well, maybe we'll have you on our podcast.
Wonderful. I look forward to it. Thank you. And say hi to Maddie for us.
I will. Thank you.
Thanks, Dorsey.
My pleasure.
All right. Yeah. And if anybody wants to jump in tonight, I'm gonna see if I can.
Okay.
All right. There we go. All right. Yeah, she was great. Absolutely great. And a lot of information there, some people. If you want to jump in tonight, Chris, if you want to just get into your letter here so we can start letting people know exactly what you're doing and what your mission is and why you're running and why it's so important to you, because we got a problem. And the problem is, as you put here in your letter, while 61.3 in the Florida statute now favors shared parenting responsibilities, the key criminal, domestic violence, child welfare, and missing persons laws still reflect outdated custody framework as an adult. And you say that these failures violate due process and equal protection under the 14th Amendment and Article 1. I guess it's subsection 9 and 2 of the Florida Constitution, and conflict with the Troxel versus Granville 530 U.S. 57 2000, which affirms the fundamental rights of fit parents.
Yes. And in short, I'll try to make it in simple English. We have old statutes on the books that predate when Florida did what they call the 2008 shared parenting reforms. So they did a complete overhaul over Chapter 61, and now they don't have the word custody in Chapter 61. It refers to shared parenting plans. And it says in 61.13 that it's encouraged that both parents have a continuing and ongoing communication or relationship with the children, right? And another word for it being in statute is to say that it's state's policy. Right? It's the state of Florida's legislature's policy that parents should have ongoing relationships with their kids. So these older statutes, the ones that predate 2008, were never updated. The ones that are not in Chapter 61, they were never updated to reflect shared parenting. So if we're talking about custodial interference, it doesn't reference when there are two parents that have lawful rights to the children. You talk about the definition for missing child. It doesn't contemplate when mom and dad are divorced and they both have rights to the child, or even if they were never married, but they both have rights to the child. If the child is supposed to be with dad and mom kidnaps the child, is the child missing? Not according to current legislation. And this is in every state. Even though the person who's supposed to have the child doesn't know where the child is, that's not how it's written in the statutes. So we need to update these statutes to reflect shared parenting. This is not we're not swinging for the fences here. We're simply asking the legislature to update these statutes to reflect shared parenting principles.
Right. It's really outdated. If you're just joining into the live, thank you so much for just joining in tonight. We're talking to Chris Felder. He's a candidate for Florida House District 74, Sarasota. That's where he's going to be running. That's where he's running for office. But his bill is for every district in the state of Florida. We need to get those out to the representatives and to your local representatives. If you're in the state of Florida, there's the National Family Justice. Alicia's on here, and I think Aubrey from another parents battle is.com is also sharing the link tree with, you can get this letter and you can email this to your representative. And also you said in here, we want to send it out to the not just the representatives, but to the states. Who are we looking for here?
State House senators, reps, and state senators.
Not Rick
I'm running to be no, not a U.S. congressman nor a U.S. senator, but the state of Florida has its own legislature, right? We have a House of Representatives for the state. We have a Senate for the state. It operates similar to the U.S. Congress. It's just at the state level. We have 120 House reps. We have 20 state senators. I'm running for one of those 120 seats for House. We're not waiting for me to get elected to work on this legislation. We've been working on this legislation for some time. The challenges have been, I want to say, just that the legislators are, it's too easy for them to say we're confused. We're confused. This seems overwhelming. The bill isn't short enough, whatever the gripe is. Fortunately, already in this season, we have a lot of attention because we've been working on this for a long time. So a lot of legislators that were eager to see this submitted last session are involved, they're engaged, they're interested in this being sponsored for this upcoming session. We have a couple of House reps that have agreed to draft. We only need one House rep to agree to draft, but I have some backups. so that we can get it into drafting. And then after it comes back from drafting is at the House, it will go into drafting in 10 or 11 weeks from now when the window opens for drafting. Then it'll come back
Mm-hmm.
from drafting. Who knows if it takes a day or 30 days. It depends on where it falls in the queue. And then when it comes back from drafting, that House rep will get to decide whether or not they sponsor it. If whether or not they sponsor it, again, we have a number of representatives this time that are eager to put their name on it. And simultaneously, or when we get that bill draft back, we'll send it over to the Senate. And we'll ask somebody in the Senate to submit it for drafting, and they'll just submit the drafting that's already been approved by the House.
I've got
And hopefully we're off to the races.
Yeah, wonder.fool. He's asking the letter where to find it. It's under the link tree just below you, National Family Justice. Just put it in there. It's a link tree at Real Chris Felder is where you can find that and send that to your representative and get that to them so they can just make some noise. Let's get this out there so they can start. The more we push it into them and get them their eyes opened up to it, the more that it's going to become something that they're going to fall on on board with, and that's what we really need to do. Let's go over some of the other ones that you have on here that the problems and the fixes that you have, because I think it's very important. And let's do one with where was the one on here about did we already go over the one for false allegations?
That's not in there. We actually took that out because the false reporting was under Child Protective Services, and we felt that was making it, not to get too far from the weeds, but they were adding extra committees at the House, and it was making it potentially prohibitive. Apparently, if you get two or three, if the House of, let me back up. If the Speaker of the House assigns it to more than 3 committees, one representative called it the kiss of death. You don't want it to be appointed to more than 3 committees. And last session, our bill was appointed to 5. So we got to find a way to tailor this bill now to where it's only going to 3 committees. And that meant taking out some of these things from this bill that we will hopefully redress in the future. This isn't it. This isn't, we get this bill done and we're done. This is really just to address custodial interference. And the part that we didn't address here, and there are like 7 statutes in that letter, but it's the bill that's not addressed in that letter, except to say this is a proposal to make sure that there's an emergency hearing. It may surprise everybody who's listening here that there's no such thing as an emergency hearing. We've been told informally by people all the time, you should get an emergency hearing. There's no such thing. It's not defined in law. What you're asking for is the court to hear a matter with urgency. And then if you're using the state form, Florida has a form for this, it doesn't cite the statute or the case law or the rule that you'd be invoking to get your emergency hearing. But the case law is Loudermilk v. Loudermilk from 1997. And that predates the Troxel v. Granville decision from 2000. So and it also predates one of the statutes on child abuse. So that case law is old, and yet, meaning like it's antiquated, and yet they're still using it as a reason to justify whether or not you get your emergency hearing, or whether or not you can pick up your child with an ex parte, meaning without the other party wouldn't get due process. They can pick up the child with an ex parte motion for pickup. So we're defining emergency hearing, and we're saying that if there's a matter of child abuse, child neglect, domestic violence, financial emergency, custodial interference, that the court would be compelled to have a hearing within 3 business days. So that would be new.
Yeah, that's what we definitely need is quicker hearings. Just want to thank everybody for joining into the live tonight. We're talking to Chris Felder, state representative candidate for District 74 in Sarasota in the state of Florida. He's got a bill. We're talking about that. If you want to jump into the live tonight, ask a question, make sure to tap that screen, get this out onto the algorithm, share it with your friends. And if you have anything that you want to add or talk about, or maybe there might be something that you want to bring up to Chris, he's happy to discuss that with you. And we've got National Family Justice sharing the link tree where you can find the letter that we're talking about and the fixes and the problems with these statutes. Healing Out Loud 2, thank you for joining the live tonight. How are you?
I'm good. I just wasn't expecting this today. Sorry. I'm just like, how us older folks are. We just stay at home, don't really do anything. This is our Friday or Saturday night. So, I was just going to ask Chris a question. Okay, so what I'm doing is I'm trying to focus on, just to kind of give you a background of me, I am trained in SA advocating. I'm trained in SPED. I'm trained in ADA. I'm trained in like everything you can imagine. You know what I mean? And I even have my psychology degree. I haven't decided if I'm going to go get my master's degree. And I'm an educator. So I do a lot of research in my spare time because of everything that's going on in my case. I was just wanting to know, I am telling my followers, considering everything that's happening on the legislative end, I am telling them all to try to write, because they're asking me how they are able to like help out or what they're going to do. And I said, you know what we need to do is we need to just flood the legislator, just flood them, because I've called the legislator myself and they have not done anything. They only just told me that they could use my case to pass a bill in the future, which I was like, okay, I guess that's at least something. But at the same, wavelength or like the same end of the rope, you know what I mean? Like that doesn't mean anything to me. With all the legislative stuff that's going through, we covered, me and my friend, I met a new friend that we started covering all the legislative, like, court hearings, or not court hearings, but hearings, I guess you would say per se, where they go in and they tell their story to the legislative board, and then they weigh the pros and cons. Well, I've been like following all of that, and I had some friends that are helping me follow all of that and post all of that. So I'm telling everybody just to flood the legislator and send the letters, send your story. Like, is that something that we should be doing?
That's a great question. I'm really glad you brought it up.
Yeah,
So
I mean,
thank you.
I'm just
And I
wondering because I just like I've been like busting out all those messages today, and I'm just like, okay, you know what? This is a great thing that Chris is on because I can actually ask him, because I would like to know, in California, there's a couple of bills that I want to pass and I want to look at passing and trying to figure out how to pass them. I haven't got to that aspect yet because, I do have to work and I do have to have a daytime job and I do have to have money to support, my living expenses and my lawyers. So,
Absolutely, right. That's got to be number one. It's kind of like you put your mask on first before you help somebody else. So here is how I would frame it. Um, Flooding is a strategy, uh, but it can also be annoying, right? So it has to be a very carefully crafted message. And I'll
well,
tell
that's
you,
what I said. Is I just to try to interject a little bit is what I put in my thing is this is going to be a peaceful protest. We are going to be sending the letters, like in my memo thing. I think I sent it to Scott today. I don't know if I sent it to you or not. I think I did in a message or comment. But it's like this is a peaceful protest. You are, me, because me, I try to be peaceful because I can't. I'm an educator and I cannot get arrested. So I have to make sure that it's always peaceful. You know what I mean? Like no matter what I do, it has to be peaceful. And that's one of the things that I want to make sure that it's okay. Because I I'm going through a lot of like what Scott's going through with my, I don't want to get into it because I might cry, but yeah, I'm going through a lot of, situations with the court in California, and I have been fighting it, this whole time. There's some times that I've had to be pro se. There's sometimes I've had to be by myself. With my first two kids, it was 10 years for them, and then this one, it's been 3 years. And I am at a crossroads where I'm like, okay, I don't know what I'm going to do. I mean, those court cases are coming up. But I told them, I've shared my story and people have reached out to me. And I told them, you know what? If these legislators have a way to try to have I'm not trying to say it like in a rude way, but if they have more ground or more of a platform to pass those bills or get up there and like actually help us with this court reform, then we need to try to do that, for them.
I'm gonna answer your question with more questions.
Okay.
How could you define the problem in a sentence?
With me?
What is the change that you're looking for in the universe, right? How do you define the problem in a sentence?
Okay, with the legislator, or I have to have details,
If you're looking to change the law in California,
Okay.
you have to define the problem that you're
Okay.
solving for, right?
So there's a couple of laws that I would like to change, our bills or codes, because you know how they use all that mumbo jumbo. There's family codes, there's, all that. I can't cuss on here, but, but I mean, but honestly, like there is so many loopholes in the system, and one of the major loopholes that I found in California is two. Okay. There is in California, if you can prove domestic violence or a felony or a misdemeanor, then that person does not get any spousal support. I understand why it's catch 22. I understand why it's protecting people, but I feel like it's being used against women in a way because it was used against me.
Well, it's probably being used against women because women are recipients of child support 90% of the time. So that's
Exactly.
probably why you feel like it's used against women. I
Because it
hear you.
was being used against me. I had to do my own rebuttal to my rebuttal presumption. I had to file all of that myself. Like when I went in, the judge like was surprised. Like literally, this judge was like cell shock. Like oh my god, like we go to years and years of law school to do this, and you're here sitting here doing this. And I told her straight up, you know what I mean? Like this is not right. He is the perpetrator. I am not. I said I have done everything that I can to make sure that this course goes peacefully. I had a settlement agreement. I had everything in place. I said, but this is being used against me and I need to get it reversed. I mean, I did
So
get
let me stop you because all I was asking for was the problem, right? And
yeah.
and in a sentence. Now, if you can write it in two sentences tops, that's what you want to do. You want to write the problem
For the
succinctly
legislature.
because any opportunity you have to get in front of a legislator, I guarantee you, if they're like, I'm going to give you 30 minutes, go ahead, knock yourself out, they will get interrupted 15 minutes into it.
Okay, so
And so you have to bottom line up front and you have to say, here's the problem succinctly, as much as it pains you, succinctly, one sentence or two sentences. And just like we were referring to earlier with the motion, when you're filing a motion to the court, you identify the problem, the relief you're seeking, and
yeah,
what authority that the court has to grant it to you. You're doing the same thing with all of your advocacy, whether you're talking to a legislator, a police chief, any policy leader. You're saying, here's the problem, succinctly. Here's the solution we're looking for, succinctly. And here's the authority. So in the case of the legislature, you can say, this is where it is in legislation. It's in chapter 1, 2, 3, 4, 5. This is within the family code or however you referenced it.
yeah,
This is what we're trying to get done. And then bullet 4 would be, would you like to hear my story?
yeah. Okay.
That way, if you're interrupted 5 minutes, 10 minutes into this, no biggie, right? You
Yeah,
did your advocacy, you got it all out. You can ask, would it be appropriate for me to follow up in a week? And you just handle it professionally that way. But if you did the alternative, so I presented it that way so I could share with you the alternative. If you said, oh, we have 30 minutes, boy, do I have a story for you. By the time I'm done explaining this to you, you'll understand the problem, the solution, and everything about me and why this is important to me. Don't do that, right? This is work. This
yeah,
isn't therapy. This is work. You have to get in there like you're doing a PowerPoint presentation in your grad school. You have to explain boom, 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 problem, solution, authority, and then you can use the rest to pull at their heartstrings and compel them to act on this. And I would guarantee that they're going to say either, yes, I'm on it, or I'll tell you what. You draft the language for me. Let my team review it, and if we like it, we'll advance it. So you might want to have that prepared in advance, going, aha, I already got the language prepared,
So,
right?
so I have to just, okay, so, okay, I'm coming into this blindly, okay? Even though I know all the codes and I know all the bills and I know all the other stuff, I have never gone in front of like a legislator or like whatever. I only called one, and I think I talked to the secretary or something like that.
I'm sure. I'm sure.
But like, so you're saying that I would go in there. How would I request a meeting though? Because I think before you had said that we don't get
You
to request
you
meetings.
call the same secretary and ask for a meeting.
Hmm.
And generally speaking, they'll say, "Oh, the representative is available on the 17th. Are you free then?" And to which you'd respond, "I can do it in person, or I can do it by Zoom. I can do it by phone." If you have a busy schedule, I would recommend you do it by Zoom. That they all do it by Zoom now, or Google Meet, or whatever. They're all available that way now. It's a very standard practice.
I mean, and this is funny. I mean, this is between like, all of us here, but like when I talk to them, they ask me, they're like, who is this person? And I was like, it's just somebody that just floats above the line. You know what I mean? Like pertaining to my ET.
You don't have to gain credibility. You don't have to be a celebrity. You don't have to be known
Yeah,
by anybody. You just have to have your proverbial stuff together,
yeah.
which means get
Mhm.
organized to where you problem, solution,
Okay.
authority. Would you like to hear my story? Just have your stuff. I mean, you can have it all written out. Nobody's going to be the wiser. And you
Yeah.
can come right out and say, I'm nervous. I've never done this before. And they're going to go, nervous. I'm just some schmo. As much as I'm just some dumb schmo that might get elected. I
Mhm.
mean, we're just people.
Yeah.
So, but some of these folks are more empathetic than others. So I would, if you get a no from somebody, you just call the next
Well,
legislator up the road.
I did get them to listen to my story when I contacted them, and they did tell me, they're like, well, we're going to save your stuff for like if we have a bill to pass, is what they said, for my story. And I said, okay, just let me know, because at that time, I was, fight or flight, mode, trying to survive, all this stuff. But at the same time, it's just like to all of us, it's like another place that's opening up to us. You know what I mean? Like now that we're able to like see the process of people going and telling their stories to the legislators and the legislative board, and like all that stuff. I'm over here trying to get my lingo down so that I'm not nervous when I go there, to make sure that
Yeah.
I know what I'm doing because like I just sent another one out today and I can't remember where it's at. It was in Arizona and now it's in Idaho and it's going somewhere else next. I just sent it out today because, of course, I'm on summer break. I'm a teacher, so I have time to do all this advocating right now. But, during my normal
Mhm.
time, it gets a lot. But the other bill
What,
that I had, you ready for the other bill?
yeah. I would just real quick. I just want to just ask you what's your name?
My name's Veronica.
Veronica. All right. Yeah. We I wanted you to connect with Chris, but we have some other people who want to jump in the live tonight,
Okay.
and so we were just trying to give people about 5 minutes to ask questions because we've got a lot of people. I want to say hi to Mal for jumping in. Heather, thank you so much for the comments. We appreciate you. They're finding a lot of great information. And seriously, Chris, real quick before she goes, how long have you been working on this? Just kind of give her some context about how long you've been dealing with this and trying to get this into legislation. It hasn't been just something you've done for a couple of weeks. You've been working on this for a while now.
Well, my own personal crusade, it's been about 10 years. This particular language is because my children have been abducted from me 3 times in the last 10 years. So I wrote the language 3 years ago, and I finally got sponsors for it from the House and the Senate last year. It was withdrawn from the House the day before session started, but we don't quit easy.
Mm-hmm.
So we're back in there again, and I rewrote the language, hoping that it'll only be assigned to 3 committees this time, so that hopefully in plenty of time for next session, we'll have drafted and in both chambers, and we'll have sponsors in both chambers well before session starts in January.
Yeah,
But it
just
does take
just
planning. And I'll tell you one more thing about these legislators and their aides. They'll keep saying, "Oh, we have time. Oh, we have time." You can't rest on your heels. You have
mhm.
to, like I was saying, Veronica, draft that language. Go find the bill you don't like and redline it. Make it say the language the way that you want it to say, or strike the whole thing if that's the idea. But
Yeah.
make be of think ahead to where you can actually put that on the legislator's desk, or if you're meeting them remotely, so that you can email it to them even in advance of the meeting. Just you can give them all the talking points in advance of the meeting, so that really all you're doing is smiling and sharing your story during that meeting. They like it when you're
Just
prepared. Everyone that I've met with is like, I can't believe how prepared you are. Apparently, people don't know they're supposed to be prepared for meetings.
I'm one of those
mhm.
So
over prepared people. Like I over prepared, but I have to also mentally have it ready.
I've made a name for myself to where even when I go to events, these legislators don't avoid me, but they walk right up to me and they're like, they shake my hand, hey Chris, good to see you again. And they
Mhm.
know that this is my shtick. I intend to get the family law system, and I say family law, I don't mean just divorce, but all of these systems that have the effect of, as much as they were made with good intentions, they have the effect of harming families just because somebody put it into law 50 years ago and then it was never revisited 5 years later to make sure that it was working correctly.
Yeah,
Yeah.
exactly.
And just remember that there's only one shot a year. You get one chance every year to get into to the bill to pass.
In Florida, and some states only meet every other year. So they
Oh,
have
okay.
fewer opportunities to change the laws in their states.
Wow.
Mhm.
Well,
That's where
Veronica, thank you so much for what you're doing, and fighting for the family law, and being a part of the crusade. As Chris is calling it, he's putting a crusade together to not just in the state of Florida, but all over, just kind of because this isn't
I'm
just
not
a
in
national thing;
Florida.
it's a global thing.
So, all right. Well, I'll see you later. I
But thank
appreciate
you. Let's give you an applause.
it.
Thank you for what you're doing, and thanks for jumping in tonight.
Oh,
All
you're welcome.
right. All right.
Thanks, Veronica.
All right. Yeah, and we are here tonight talking to Chris Felder. I know you're in the car. It looks like, yeah, if you still have some more time, I'm sure we got more people that are engaged. They're still asking some questions. You want to talk about anything more specifically that we haven't got to yet?
Not necessarily. I I think I learned something today that was really upsetting. I don't mean to derail this. It is a little bit off topic. I learned that there's a system. Are you familiar with Baker Act?
Yes.
So there's a system that runs parallel to Baker Act. Oh shoot! Now I forgot what it's called. Um, oh, I'm gonna have to find it.
All right. Well, while he's looking for that, if you want to jump in the live tonight, Mama Love 23 waiting 6 months for a court date. 6 months. What state are you in? Oh, Miles, you're restricted. Yeah, the algorithm is very tough on some of the content that you put out, especially when it comes to domestic, DVs and essays and certain things you say. So you got to be very careful on what you're saying in your content, or the algorithm will restrict you. You got to be very PC on TikTok, as they like to say. But we got if you want to join in, just put a 1 in the comments. We'll get you in. You can ask Chris some questions. You had something that was on opposite of Baker Act.
It runs parallel. It's called the Marchman Act, and it
Okay.
has to do with children who are, I guess, in need of drug therapy. So there's supposed to be this state funding that helps, much like Baker Act, but it's specifically for children who have gotten into drugs, and it's not being funded. And I only found this out because of a mom I know in our community that her child is 16 years old and found her way into drugs. And so she's trying to utilize these resources. The mom is a lawyer. So she did all the research to understand this is a system that's supposed to exist in Florida. It's supposed to be in Florida for a number of years. I still have more research to do on this, but it stopped being funded maybe 2 decades ago. It's just not
Hmm.
funded, despite the fact that it's obviously there for good reason. It's there to help children and families. But somebody in the legislature thought that this was not an important initiative. I'd like to bring that back up. I think mental health and I think drug abuse is a critical issue to address.
Hmm.
I don't know how you can push that back on families that aren't equipped, right? They don't know how to handle it. And with fentanyl and all these other issues that are facing our country, I don't know how we could, uh, as a legislature, as a state, turn our backs on these people because their issues are, we have more important issues than those. I don't agree with that sentiment.
Yeah, I mean, it just goes back into like it feels like at some point that the family laws and family courts, the kids are the ones that really get kind of pushed to the wayside when the parents battle it out. And when you go a step further for those who are dealing with that, the family trauma and the trauma that they're dealing with, there's no help for them going through this. So is that something you're going to plan on rewriting into your letter or into any of the bills?
I just heard of it today. So yes, it's on my table, it's on my desk. I'm trying to figure out what one can do in the way of proposing a change to policy.
We got Mama Love 23. She's in Florida, and she's going through the same thing that I'm going through, that every parent's going through. They're waiting 6 months for court dates, and that's the status quo. And 6 months that's not even. I mean, I hate to say it. The first court date isn't even going to be a trial date. You're going to go to a case management hearing before you even get to your trial. There's a
That would be the
process
normal order. That would be the normal order of things.
And that's what a lot of parents don't understand when they go into family court. And I think, that where we're lacking a lot of the education and knowledge for divorce, for people approaching divorce court, that there is a process that handles this. Your attorney doesn't really explain that process to you. They just going to tell you, yeah, we're going to heal you. We're going to get this fixed right away. And then you're a year later, you're like, what is going on? Why can't I get in front of a judge?
And they will then encourage you to, right or wrong, I mean, they may be coming from a good place, but they'll encourage you to hire these guardians ad litem, parenting coordinators, social investigators, and all those people. Not only do they drain you financially, but all they do is delay it. So if you go get a social investigator, I think we now have a new rule in our community where it can't be more than like 170 days. But my social investigation was a year and a half. We just couldn't get the guy to finish it. He just refused to finish it. And meanwhile, we had to pay him, the psychologist, we had to pay the attorney, we had to pay everybody else just because. And I'm not telling anybody in this room anything they don't already know, but the first thing you do when you step into this foray is provide your financial affidavit. So they know exactly what you have, and can become a race to the bottom.
Yeah, it's you know what, and then I feel for everybody, and this is just one of the things that what you said, like, why are we dragging this out? Why does it take? It took longer. It took no time. My divorce went through in like 5 or 6 months. It was finalized. Went to mediation. I think the attorneys said, you know what, Florida is now a presumption of 50-50. Told my ex that you take this to trial, you're not going to get what you want. There's nothing, you don't have anything that's going to change this. You have to shock the courts, is what I was told, to get anything less than 50 or anything more than 50-50. But once you get past that final judgment, then it's like open season. You can file the motions, you can do everything you want, and that's where the real game starts.
Well, and then trying to get your original orders enforced. Right?
Yeah.
That can be a challenge. Here it is. You're trying to get your kids when you were already supposed to have your kids. How do you convince a court to enforce its own orders? It is unreasonable, and we need to write new policy that gives the courts a lot less latitude. I don't like the child's best interest. I think that's terrible. it should be in the absence of detriment. The court's going to enforce its own orders. Right?
Mm-hmm.
If the court finds detriment, okay, then we get involved and we make sure that the child's being kept safe. But in the absence of detriment, what is this whole preponderance of the evidence stuff? It makes it all subjective. Whoever has a better story, whatever the judge had for breakfast, whatever side of the bed the judge woke up on, it's not reasonable. Which, of course, again, is why it should be challenged for being unconstitutional. But from a legislative standpoint, I would say we change it to where it's 50-50 unless it's detrimental to the child.
Mm-hmm. Yeah. So here's a something you can use. This is something I came up with last year. Campaign slogan, if you will. You ready?
Ready?
Resolution is the best solution. Resolution is the best solution. Let's get to a resolve. Let's stop dragging it out. Let's resolve the issues as soon as possible.
Resolve the matters in the legislature or in your court proceeding?
For family court. Like resolution is the best solution. Dragging it out is not a solution. The best thing for the kids is to get this to resolve quickly as soon as possible, and that is where the healing begins for them and holding them accountable, and that's part of the resolution.
I agree. Now upstream, somebody's going, well, hold on a second. I mean, heaven forbid we just get more judges, right? If we had more judges, maybe the docket wouldn't be so clogged. But somebody upstream is saying, well, we don't have the money for that. Well, I would argue, how do we not have the money for that, right? How is it that tearing these children and these families apart is in the best interest of the state, right? It just doesn't make any sense. And I can get into some of the Supreme Court rulings where they argue that the state should not even be involved in our families unless there is evidence. The terminology is unless there's a compelling state interest. And that is code for if the child is being abused, if the child is being harmed. Otherwise, the court's not even supposed to be, the states are not even supposed to get involved in our lives. And I don't mean to sound libertarian. This is what it says in the Supreme Court ruling Troxel v. Granville, and that was reiterated more recently in Mahmoud versus Taylor. This is the Supreme Court.
Hey, so if you're just joining in tonight, we're talking to Chris Felder, representative for the District 74 State House in the state of Florida. If you want to jump in and ask a question, we got, I think that, maybe we could start wrapping this up pretty soon. We've got some time for maybe a couple more questions. Chris is, he's been doing this, if you heard earlier, for 10 years now, and he's been trying to rewrite the laws. He's got a problem in the fixes for what's wrong with how it's written and the language that's written in it. And, Alicia shared this with me earlier, so I'm just going to kind of put this out there too, that the simplest thing that people can do to help Chris is to follow him on every platform they use. If you want to support his campaign, he's at Real Chris Felder on Facebook, Instagram, X, TikTok, and YouTube, True Social, and Rumble. He has 35 followers on YouTube, which that's insanely low, and the numbers, because everyone has a YouTube account. So go over there, follow him on YouTube. We need to spread him on all platforms, and tagging and contacting your Florida legislator. Florida has two levels of elective lawmakers. There's the state senators and the state representatives. They write the state laws. The U.S. senators and U.S. representatives, they write the federal laws. We need to focus on only Florida state senators and state representatives. A U.S.
And these
senator,
are only state issues. So as much as people seem to think that marching on Washington or calling their U.S. representatives would be effective, it isn't. The family is very much exclusively in the state, as much as murder is in the state. It's not a it doesn't belong in the U.S. Congress.
And if you want to find your state legislators, Google "Find My Florida State Senator and Representative." Enter your address on the official government site, and it will show you your Florida State Senator and Florida State Representative. Even if you don't live in Sarasota, which is the district that Chris is running in, your local legislators will listen to you because you're their voter. And if you feel like this bill is going to protect you or someone in your family, maybe maybe it's your child that's going through this. And I know a lot of grandparents have reached out and said, yeah, my kids are going through this. They're going through this issue. The system is not fair to them. I can't see my grandkids. Or if you know a family member that's one time, a friend of a family member. Here, I think there's a script, you got an email that you could send to your legislator. Alicia, she's on here. She's the one that sent it to me. I don't know if there's a template for this email that people can use, copy and paste. You can put your name in there, where you're at. You can email it to them, and give them Chris's information where they can reach out to him if they want to discuss more about this bill as we're heading into legislation in about 6 months from now. So, yeah, if you have any questions, you want to hop in the live tonight, thank you for joining in. Thanks for liking the page. Georgia Shared Parenting is on. They said 50-50 is one of the only policy changes that could help tens of millions of kids for free. And I think Florida's there's only a couple of states right now, presumption of 50-50.
Yeah, there are only a few. And which is mind-boggling. It absolutely is mind-boggling. But I think it's because of how some of these arguments are being framed. And some of the arguments are being framed as a father's rights initiative or something else that naturally has an opposition. I mean, we got to be diplomatic. We got to be politic. You have to understand the room you're in, and that you have to frame it in such a way that makes everybody, it's inclusive and gets everybody supporting you, as opposed to walking into the room, having shown everybody you kick the dog or you kick the hornet's nest. You don't, like we were saying earlier, you don't walk into the room saying, you're corrupt. That you have to win friends. You got to influence people. You can't just go in going, this is obvious, make this a law. That's not how the Capitol works. So we have to frame it as, in this case, a lot of the stuff I'm working on now, we're framing it as child safety issues as opposed to a parental rights initiative, because the parental rights seems to upset some people, or to suggest that it's a father's rights obviously upsets people who think that they're protecting their children from fathers.
I just invited George up. Let's see if he's going to jump into the live here. For the live, Alicia suggested that we should pull him up here to talk, and they said that they helped Florida get 50-50 presumption.
Oh, yeah?
That's what Alicia's saying. She said, Georgia Shared Parenting, Chris helped get 50-50 for Florida. Yeah, I sent an invite.
I think she's saying Georgia. I think she's meaning Georgia.
Georgia, okay.
Yeah. So the person who is calling themselves
Georgia Shared Parenting?
Georgia Shared Parenting. I think that's what she's saying, is that talk to Chris, because Chris got Shared Parenting.
Oh, okay.
In Florida.
All right. Yeah, if you have any questions tonight, go ahead and jump into the live here. We thank you for joining in. We've got, here we come. They're popping on in here. Hello, welcome into the live. Georgia Shared Parenting. What's your name?
Hey, Justin.
Hey, Justin. Thanks for joining in.
Yeah, good to see you guys. And I just kind of jumped in a few minutes ago. I had some family stuff I was caught up with, but no, good stuff, Chris. Yeah, I've been watching Chris's stuff come out recently. All good content, man.
Excellent. Thank you. I'll tell the team. I'm sure they'll be very happy to hear that.
Yeah, for sure.
So what's in the state? Obviously, Georgia, they're shared parenting now.
So no, Georgia does not have shared parenting. You're asking about the current state of the custody laws here?
Yeah.
Yeah, no, Georgia does not have a presumption of shared parenting. We still use the high conflict, best interest of the child presumption, which everything that y'all been talking about, right? You get contentious court cases, you get whatever side of the bed the judge happened to wake up on is pretty much how they rule. And we have a lot of judges in Georgia who actually, this is wild to me when I started figuring this out, but a lot of judges in Georgia will literally yell at parents in the courtroom for trying 50-50. Judges have used the words, "you're stupid for attempting this," even when parents agree to 50-50, right? They can come in with an agreement, everything laid out. They're very low conflict. They present it to the judge to get it signed, and the judge will say, "You're stupid for trying this." So we are very far behind here, but we're trying to change it. We're trying to push out some advocacy here and get some movement.
Do you know the name Pennsylvania Representative Jamie Flick?
I know the name. Yeah.
So he and I spoke last a week or two ago, and he was sharing with me his story. He had a very amicable divorce, as it was at the time, and the mom and dad presumed that it was going to be a 50-50 arrangement, and then the court ruled and gave him only every other weekend.
Yeah,
That's when his fight began.
and that is the wildest thing, that with all the research that we have, all of the studies, everything showing that the best interest of the children, I hate to use that term, but the best interest of the children is to have both parents fully involved in the lives of these children. And the parents seem to know that. You can take it to court and not get, and actually get the desires of the child, the mother, and the father all overturned by a rogue judge in the courtroom. It's wild.
Yeah, it absolutely is, and it's because the parameters are so broad, right? If we can narrow those parameters for judges so they don't have the latitude, which also means overriding years of case law. I found case law from the 90s recently. This is Florida, but it said these are all the reasons why when it's the court should act with urgency, which you'd think that would be any instance, right? Because the state's so interested in the child's best interest, we should always act with urgency or timeliness. And the examples it used or came up with in the mid 90s came up out of thin air. There is no example that they're calling on that precedes 1995. Just out of thin air. We're going to decide now that these are important issues. But if it doesn't fit in these criteria, we don't address them timely. And I'm saying that as an example that I'm finding it in other areas of our law that they're just made up by the court out of nowhere. So the legislature, I'm pointing at myself because I'm running for the state house, that we need to narrow that and define it. That's one of the things that we're focusing on this upcoming session is to define an emergency hearing to make sure that these particular things are addressed within 3 days, which is not
Right.
just when the child's facing imminent physical danger, because we have other legislation that says that emotional injury is not subordinate to physical injury. They're both on the same priority, but the
Right.
courts won't address the emotional injury timely.
Well, and
You have
they won't address things. They won't address things that you think should be right, timely and potential danger to the child. But then they will address things like I hear stories all the time. People sending me DMs on different platforms about how they're being taken back to court for an emergency hearing because one party thinks that they are owed $34 from a medical bill from 2 years ago that they forgot to pay. Right. And it's like, you've got 30 days to respond. This is an emergency hearing. This has to be heard within 30 days because this involves finances. And the
oh my
mother thinks
goodness.
that she won't be able to pay her bills or whatever it is. Right. Whatever the legal argument is that they try to make there. It's like, and then you dig into the case and it's like, well, yeah, mom does have to pay her bills. I get that. Like, okay, let's dig into this case. What's going on? You read the document they filed and it's like, okay, you think you're owed $32 from a medical bill from 2 years ago. That like real, and this is what we're tying up our court resources with, really. Like we have kids that haven't seen their parents in years, parents that can't get on the docket for a hearing, judges that are wasting time with this, right? So no,
Yeah, that doesn't
totally.
make any sense.
It's like everything is flipped backwards. Right?
Yeah, Justin, is Georgia Shared Parenting an organization?
No, not officially right now. There have been a couple, if you go on Facebook or Instagram or whatever, there have been a couple attempts right now, but no, it's right now it's just me and a few supporters.
Are you a member or follower of National Parents Organization?
Yes, and yeah, I'm in contact with several of those guys there. I go back and forth with Mark Ludwig a good bit there,
Well,
and
he's different. He's not NPO. He's the Americans for Equal Shared Parenting.
that's right. That's right. Yeah. So Don Hubin, I think, is NPO, right?
Yes.
So I've been back and forth with Don Hubin a little bit. Mark Ludwig also different organization. Thank you for calling that out. Yeah, Don Hubin, and then I know she's not related either, but Emma Johnson. I've spoken with her a little bit.
Yeah, that's different.
Yeah. So I know those are all different organizations, but trying to stay tied into as many of the big brains out there as I can.
So I'm the Florida chair for National Parents Organization. I would encourage you to look up who the chair is for Georgia, and I'm happy to send people to you or vice versa. We have people in Florida who have cases in Georgia, and there just needs to be more uh, more activity in Georgia, we'll say, but not to confuse activity with productivity.
Hmm.
Uh,
Yeah, right.
Here in Florida, we regrettably just weren't going anywhere as an organization, NPO. And I was asked to be the chair. I can't remember when it was now, 3 years ago, and we've come a long way in 3 years. So I would encourage you to join that group, and however it is the Florida group can support you, please let us know because we're stronger in numbers.
Yeah, for sure. Yeah, let's keep in contact. I'll send you something after this because yeah, I've reached out to a couple of the Georgia specific NPO folks. I don't believe that I've heard back, but maybe you can help me get in contact with them.
Okay, yeah, please. You can email me at Chris Felder, no separation, just first last, at sharedparenting.org.
Yeah, for sure.
All right. Hey, Justin, thanks for all that you're doing, for fighting for those families in Georgia, and thanks for jumping on the live tonight.
Yeah, thanks, guys.
A little round of applause for you.
Thanks,
We need more
Justin.
fighters. I want to thank for all the comments coming in. Stacy, thank you for the comments. And Gabby's made a couple of comments here, and that's something that we touched on earlier. She said that Netflix has picked up a docu-series for corruption in the family court system in San Diego, California. You want to tap on that again? The verbiage there, and then the documentary coming out. It must be a specific situation, because I like I said, there are some bad actors. I'm sure that there's somebody that's got some money in their pocket somewhere, but for the biggest picture of it, you just think it's just outdated laws, and that there's no real intent for harm.
Well, there was that one big scandal in Pennsylvania, if everybody's familiar with the Kids for Cash scandal. That was truly corruption, but it was two judges. It wasn't the entire system.
Right.
There was another instance, famous instance, apparently, that I think it was Houston, that it was all corrupt in that system. I think it was around the turn of the century, so it was around 1999, 2000. And I think there might have been like a miniature one in Los Angeles, probably not the entire county, but one little area where it was evident that there was some corruption in that space. And I know there have been a lot of recent accusations that St. Louis has some corruption, but I think that they've never been able to really uncover any evidence of it in St. Louis. I think it was just people speaking recklessly, and then the reckless comments that some of these people were making within the system. Uh, Advocates latched onto it and thought, there they said it. There's the smoking gun. They admitted it, and I don't think they admitted anything. I think it was just people speaking recklessly. I mean, wherever you are, there's people who in every profession that aren't smart about the words that they choose, and many people are not really good at their jobs. The number of people that I meet still that say, well, I've been practicing family law for 25 years, and then I have to respond with, all that means is that you haven't had your license revoked. I mean, just the fact that you've been had a license is not evidence of being competent. It just is. Um, and I fault our family section of the Florida Bar, which was started in 1971, 20 years before we even had a family court. Florida didn't have a family court until 1991. And why is it we have all these problems with legislation when the family section, a significant role of the family section of the Florida Bar, is to lobby to reform these laws? Why is it feel that the laws that they're reforming are just to make sure lawyers get paid, not to actually effectuate solutions and help these families? But this bill that we're talking about for this session, the one that's going to make sure that these matters are enforced by law enforcement, by DCF, by schools, if these laws are enforced there, we don't have to go to the family law courts.
Mm-hmm.
So that'll free up the family courts to handle the real issues. Right? Alicia liked to say that if law enforcement would actually enforce custodial interference, it would alleviate how
Mm-hmm.
many reports they get or calls they get that they can't act on. Right? I was it wasn't my study, it was the Miami-Dade Police Department before they became the Miami-Dade Sheriff's Office recently. But they did a quick study of the numbers I think it was like last March of 2024, to see how many call clearings, right? So when they go to a home, a domestic call, and then they clear it saying that it's a civil matter. I think I'm using their terminology correctly. So they call it a civil matter. And so they went through 12,000 of those cases and very quickly found that they were dismissing these cases inappropriately, unlawfully. And the lieutenant was told by his superiors to stop counting once he got to where he identified that it was happening more than 5 times a day. More than 5 times a day, that one law enforcement agency, there are 31 law enforcement agencies in Miami-Dade County, the sheriff's office obviously being the largest, but one agency had more than 5 of these reports that we're talking about every day, and they were just dismissing them as civil matters. And we can say as lay people, as citizens, whatever, it's corruption or whatever. But I'm telling you, these guys don't even know it. They're not even aware of the statutes. It's not part of their training.
We got if you're tuning in to the live tonight, we're talking to Chris Felder, for candidate for State House Representative, State of Florida, District 74, Sarasota. And I want to say thanks to Megan she's jumping into the live. I think she just had a request. Megan, did you? I sent the I approved the request. Did you want to hop in here tonight and ask a question with Chris?
And then if after this question, if it's fair, I'd like to head inside. I've been in my car all these hours. I got kids inside that probably need my attention.
All right. So, okay, she just wanted to listen. Well, I tell you what, we're gonna I'll get this live out. We'll put up some clips and some highlights and some important stuff. But Chris, thank you so much for the time. Listen, Chris is okay. Let's see if we got one more. I had issues with DV before OJ went on trial, and it's still not better. Oh, this sounds about right for a lot of people.
If the glove don't fit.
All right. So
when can we do this again? I think they'd love to hear when we're going to be back.
Yeah, I mean, what do you think? I mean, I'm open to doing this as often as you want to get out there, once a week, couple every other week. What do you want to do it? I mean, people are on TikTok all the time, and the more information, the more that we can get this out there, the better. And I think that it's just going to grow.
Well, I'm comfortable with this time slot, but if you want to try other time slots, we can do that too. We'll see how the TikTok world responds.
Yeah, I mean, it seems to be going so good, pretty good this far, 7:00. I mean, as long as there's any schedule conflicts. Stacy says, shorten the window of discretion the judges have. They have a lot.
Ditto. Absolutely. Yeah. We got to narrowly tailor that so that they have very little discretion.
But yeah, I want to thank everybody for joining in. Make sure to follow Chris. Again, it's not just that the state of, his district, Sarasota, but we got to get the letter out there to all of the districts. Gabby, thank you so much for tuning in. And we're going to try to, let's do it again next Saturday, 7:00. Maybe you can find a better place in the house. We'll get you, so you don't have to sit in your car. You have to go charge it tonight. Follow Chris at Real Chris Felder on Facebook, Instagram, X, TikTok, YouTube, True Social, and Rumble. And let's just start subscribing to those, start spreading his word, start getting that letter. Alicia at National Family Justice, if you could throw up that link tree one more time for everyone to get that letter, that'd be great. Send it to your representative. Do it every other week. Send an email. Just keep banging it into their heads and letting them know this is what the problem is. And there's so many people that are affected by it, and they're dealing with this on a daily basis. And the reason why I call it a silent epidemic, I know you don't like to use that term, but is it because it's the only people that know about it are the ones that are dealing with it. The people outside of the family court system, it's not an issue for them. But if we can get the word out to them and let them know, hey, there's a problem that's a hidden layer that people are hurting inside the family court, then maybe we can get more people involved with it and not just the ones that are being affected by it.
Absolutely. It's ubiquitous. It's facing every corner of the country. All 3,500 counties are reeling from this, and nobody's bringing the solutions. Instead, we're talking about other things in politics that are completely unrelated to fixing our current situation at home.
And again, those that letter, the National Family Justice, she's put the link up there for you again. It tells you what the problems are with the statutes and the fix that Chris has for them, just in a single sentence, just like you were telling Victoria earlier. If you could just find the problem in one sentence, what is it? And that's how you put it right there in your letter. Short, simple, sweet, and easy. It's not 13 pages long. It's barely 2 pages, and that's what they need. Something easy for them to comprehend.
That's it. And take a stab at any drafted language. Find a statute you don't like and redline it. Write it the way that you'd prefer it to say, or to say what, how you'd prefer it read.
And if you're listening from a state that doesn't have the, going through the same issues, take a look at it and compare it to your state laws, to the statutes and how it's written, and see if you can do something and start making those for yourself and start giving it to your legislators. And make sure to credit Chris Felder on that.
Well, thank you for everybody who stepped up. Dorsey, Veronica, Justin, Brian, thanks everybody.
Yeah. Big round of
Thanks for all
applause.
your
Thank you
questions.
so much, Chris, for what you're doing.
Alicia.
And we'll do it again. Alicia, Aubrey, she's been hanging out all night too as well. And I see Maddie. She's been quietly watching from the shadows, but maybe we can get her on here sometime talking about it too as well. So
That'd be great.
Parental alienation. It's harmful to not just parents, but more importantly the kids. Comprehensive change in those laws can protect them, and that's the goal here. So. Thanks for tuning in. Lost in the Divide, Chris Felder, state representative, candidates, and your campaign begins next month, correct?
Oh, no. It's already started.
Oh, okay.
Yep.
The official kickoff.
ChrisFelder.com.
All right. Chris, have a great night.
Right.
Go inside. Have fun with your kids.
Scott.
We'll see you
Thanks,
next
everybody.
time.
Good night.
Good night.